Thank you very much. I will invite the Honorable Justice Ouko to begin with these questions.
Thank you, Judge President. I have a couple of questions. I'll start with Mr. Mahat, who, without leave, proceeded to convert this courtroom into a classroom. Mr. Mahat, there was an allegation that 33,000 vote differential were noted between the votes cast for the president and those for governor, senator, women rep. You tried this morning to explain that some of those instances arose from stray ballots. Would you tell us how many constitute stray ballots? And can you also share with us how those stray ballots are distributed in terms of counties? Related to that, did you have, in your analysis, did you have any instances where voters walked into the polling station, voted for the president, and no other candidate or no other category of candidates, what in this court we call the Mwilu question, in reference to my lady, the vice president, I think arising from the 2017 question that I think my lady and my lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IEBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission or he was gazetted as national returning officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters who were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Raro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the qualitative, the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it? And what is the approach you should take in this case regarding the test to apply? Number two, again to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have...
Alafu hapo wale tutatathmini atakayosema. Bila shaka basi kikao hicho kama kijaanza bado tuweze tu kupitia ile ripoti ambayo ilikuwa imetolewa hapo jioni, ambapo walikuwa wanasema kuwa kulingana na yale ama vile vitu ambavyo vilikuwa vimetarajiwa kuwa viweze kuangaziwa tena, kura ziweze kuhesabiwa, na kwa kufikia hivi sasa takriban vituo 9 havikuweza.
For the further hearing of the presidential election petition number 5 of 2022 as consolidated with petition number 1, 2, 3, 7, and 8 of 2022, Raila Amolo Odinga and 7 others versus William Ruto and others. The Honorable Chief Justice, President of the Supreme Court, is presiding.
Thank you and very good morning to the court. I think yesterday we agreed on the order of business this morning. The team led by Senior Counsel Professor Muigai will have 15 minutes to respond to the questions that were 30 minutes to respond to the questions that were raised yesterday.
Good morning, Madam Chief Justice and the distinguished judges of this court. We are ready to respond to the questions that the court put to us at the end of the day yesterday. I have Mr. Mahat Somane, who the court has already found a fairly useful man in explaining numbers, and he will be responding on the numbers. But I have brought on board Mr. George Murugu, who is very, very well acquainted with the architecture of the electoral process, and both of them will be responding in the 30 minutes that you've given us. But there was a question directed to me personally by Lady Justice Jokindong, and I will deal with that question at the very end.
Good morning to all of us again, and Senior Counsel, just before your team starts, On the question of voter turnout, and as you respond, please bear in mind the following so that we know that you are answering our concern. In Forms 34A, some of them have the rejected ballot. That's what Mahat taught us yesterday. Added to the votes cast. So that the figures on 34A are not necessarily the figures in 34B and not in 34C. So tell us, as you answer the question in your own manner and style, on voter turnout, was it calculated on the numbers in 34A, B, or C? Senior Counsel, you understand our concern? Thank you very much.
Madam Chief Justice and President of the Supreme Court of Kenya, honorable and distinguished judges of this court, my name is George Murugu. I am here to answer questions that then the bench put to the Commission and to the Chairman. I will be as brief as possible, noting the little time that I have, and I hope that I'll be as useful to the bench as my colleague Mr. Mahat has been. Now, I will straight away start with the questions that were put to the first and second respondent by His Honorable Justice Ouko. And the first question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that will be issued with ballot papers for all elections in a multiple election, that is that Regulation 69.2. At 69.2a, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But Regulation 77E, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.1, the head of Regulation 3D then addresses the question of unmarked ballots. Regulation 81B, it is a direct one, and the answer lies in the Constitution. Article 138.10 places an obligation upon the chairperson of the commission to declare, but specifically for Article 138.10 to fulfill that role, to take up that responsibility, to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the Gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138.10 would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the Gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result. Beyond that, it is superfluous. And I urge Madam Chief Justice and honorable justices of the Supreme Court that that particular gazettement should not be read to mean that the chairperson had gone rogue, that the chairperson had taken upon himself and arrogated unto himself a power that he did not have. It is the Constitution speaking. It is in fulfillment of a constitutional expectation and obligation under Article 138.10. If you allow me, my colleague Mr. Mahat Somane will address the other punctuated questions that don't feature in my presentation. I will address the questions posed by His Honorable Justice Mr. Lenola. And this question is to do with the understanding of the state of the law as far as Section 83 of the Elections Act is concerned. And this is our submission, that the law is in a state of flux. Why do I say this? In 2017, the statutory provision that then existed suffered an amendment through Election Law Amendment Act number 34 of 2017, effectively repealing the 2017 provision. Now, the new amendment similarly suffered terminal fate before the High Court in the Katiba Institute case. Therefore, one would be tempted to argue that as far as Section 83 is concerned, we have no law. But in my humble opinion, I would be more kind to the state of the law as it exists. It's in flux. Why do I say this? This court had had opportunity to address questions of what happens to a repealed statute when the replacing statute itself suffers the same fate in the BBI case. And there was differing opinion, understandably so, because it's not a question that can be easily rested. In my earlier days, if you ask me, I would say there's no power to animate the previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election. That safety net is to be found in Articles 81 as read together with Article 86, and specifically for purposes of a president, which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138.10. So that at Articles 138, 3C, there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. Right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, sorry, 2, where counting is involved of votes cast, and Article 138.4, which then sets the criteria for declaration under Article 138.10. So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies? It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process, and were ready for announcement by Professor Guliye. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Guliye, filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions, and injuries to officials, including commissioners. In his mind, it was prudent to conclude the exercise since Article 138(3)(c) had been fully satisfied. And there was a legitimate expectation that the results were to be declared on the 15th of August, as had been announced on that very morning. I'll quickly address the questions that were raised by Honorable Lady Justice Njoki. The term commission used in multiple senses. How do we know which sense is applied when? My quick response: it is a question of the context in which the term commission is used. Section 2.1 of the IEBC Act defines the commission to be the IEBC. Section 11A then breaks it down further to provide that there is that policy organ which is then constituted of the commissioners, including the chairperson, which then tasks itself with oversight, strategy, and policy, and the secretariat that then deals with administrative issues on a day-to-day and executing matters of policy that then the commission, or rather the membership of the policy organ directed. Therefore, in my humble submission, it's a question of context on how the term is used. What are the checks for this all-powerful chair? For instance, if he was to announce the wrong results or be incapacitated in such a manner that then he could not declare the result. The checks are to be found within the constitutional and statutory framework. Follows. Article 138 then speaks to the checks. Article 138 3C speaks to a verification and tallying process that then engages the commission, the body corporate, so that there is no room for the chair to act as a lone ranger. And while I'm at this point, it is important to point out that in this particular case, Article 138 3C was fully satisfied. My lady, my lords, a narrative has been created that certain commissioners were given roles akin to domestic services. Nothing can be further from the truth. We all saw it. We all saw the commissioners interacting with the results, interacting with the verification and tallying process. We all saw them announcing these results. We cannot unsee what we saw. But then, just to lay emphasis on this, I would wish to quickly refer the Honorable Court to paragraph 40 of the Chairperson's affidavit, Wafula Chebukati, paragraphs 8 and 9 of the affidavits of Professor Abigulie, and paragraph 7 of Boya Molu, which speak to the truth of this issue. Quickly, my lords, on the last question, on the issue of agents and their roles. Agents play an important role in the electoral process. It's up to the parties and candidates to appoint them. But for purposes of Regulation 79(7) and 62(3), the absence of agents does not invalidate proceedings at the polling station. That would be the end of my presentation. Unless the court has any question for me, I would ask to resume my seat. Thank you, and invite Mr. Ma.
My Ladyship, CJ, Chief Justice of the Republic of Kenya, My Ladyship, the Deputy Chief Justice and Associate Justice of Supreme Court, I will try to waltz and do very fast because I'm short for time. I will mention the judge who asked the question and I will give my answer precisely. Justice Ouko asked the question that 33,000 votes, there's a variance of 33,000 votes between governor and president. Nothing could be further from the truth. The variance between the presidential and the governor is 24,000 votes. The same can be accounted for stray ballots. He asked the question, what are the stray ballots all over the country? We have to look at all those ballot boxes to get what are the exact stray ballots in those. But I did a bit of analysis, and I've attached the analysis in Kibra and in Makadara. It is 2 per polling station. And the beauty about this is late last night, I also ran an analysis on the scrutiny report that we were given for the 18 polling stations, the report of the registrar. It exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations, even if you looked at the scrutiny report. That gives you a figure of 92,000, the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that, you know, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and if that could run, the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballot. So to the question that someone can vote for one candidate and leave the others, it's not true. It's actually, the regulations don't allow. It's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence, 229. I think the number you are interested in is how many people voted manually, 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kids, right? The second question, Justice Ouko said, Omtata says 1,665,412 people curiously voted for when the polls closed. And I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it. It sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah. So that is how the number changes. The polling will close, but some kins will be sending the people, how many people went through. And it's only when we know when all the KIMs have transmitted and we know how many people have voted manually that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commences on 6 a.m. on the next day. Some places in Eldas, KIMs reported happens once the network, once it has network, and it requests to connect. So I think it's a false analysis because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMs will keep on giving that information. Justice Lenora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training Form 34A. I have also given the password. The court can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper. It will ask you for the grayscaling, and you will see how we do it. And we do for JPEG because all your phones take JPEG. We want to differentiate our image from from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start from. The reason why we give turnout is a measure of transparency and integrity to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the Kim's 589,961. On 10th August is 21,926,565. If you deduct those numbers and you compare to the people who are actually identified by the kits, actually, the people who are identified by the kits is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So, 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reach 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified under the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMS have reported. So when all the KIMS had reported, because this is a snapshot of that information in time, when all the KIMS had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that polling station we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deployment of infrastructure and the servers platform. They did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact, the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there is no agent, Justice Mulu asked if there is no agent, what happens? The integrity, the processes that we have in terms of the KIMS return, in terms of the portal, even if there is no agent, we can actually confirm what happened. So it's not the role of even if someone said I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have, go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the IEBC logo in the background, both images, same. If you look at the exact paper fold in the bottom left corner of both images, same. The image is brightened to show that it has undergone editing. That's the top left is dark. The agent copy is in JPEG. The form is uploaded on our form is uploaded on the portal 10th of August 2022 at 2 days later. And we have put that in our affidavit, actually. You can check all the edits.
Sorry, Council, you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave two examples. If you can just go back, I think I'll start with the first one. The 185, yeah. If you can go back.
We'll give you 5 minutes, yes. See what you can do with it.
Yes, yeah, thank you so much, Madam Sinje. So what we did is we just took the form they provided us and we juxtaposed as against what we have. And we've marked all the places what is wrong with that form. And what is wrong with that form? If you look at the QR code, up on the left, on the right, and also on the left, the QR code, it's cropped similarly in both pictures. The IEBC logo underneath the document coincides with what was the pressing officer. It's actually an impossibility. I've given you a form to take a picture, and what you are producing me is actually underneath the logo of the document, the IEBC logo that the presiding officer was using. So I've given you your form, you're taking your picture for your agent, and you're using the same that the IEBC PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact, you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's not any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong. The exact same fold. It's an impossibility. I mean, you have 41 polling stations all over the country, and the form they are giving is at the same elevation as what we have given. The picture that our PO took on the background of the Kim's kit is the same. And you can tell, and the reason why we were saying that it's an impossibility is because there's nothing else you can change from those forms. You cannot change the signature of the agents. It's an impossibility. The only thing you can change is the tallying. You can try change into JPEG and try to amend the tallying. And that is really important. That is the crux of this matter, and the court has to look at that and actually make a finding. I will try to also to Justice Ouko's question about the stray ballots. I just want to mention that the court report bears out the assertion of the IEBC. If you look at the report that was done relating to the stray ballots, I went through the court report and actually tallied the stray ballots. it is 2 per polling station. If you project this to the whole country, there will almost 90,000 stray ballots. And the way you account for stray ballots is they are put in the polling day diary, PSD. I have provided the polling day diary for 2 of the constituencies to just give the court comfort that as IEBC we can account for each and every ballot. To the question that has been asked by Justice Wanjala on the turnout, a clarification was given, and this is the assertion of the petitioners. They are saying, we are not interested in the clarification given by the chairman. We are going to take that turnout of 65.4 as against the total registered voters, okay? Then come to the conclusion that there are votes that are unaccounted for. And we are telling him that is not how we do it, okay? Turnouts, we give the number of people who either have passed through that kit at a snapshot, okay? And there's nothing much about it. The declaration is made on the actual physical ballots that we count. We count the physical ballots. After counting the physical ballots, we tally it. Madam DCJ asked about the rejected ballots, whether they are different from the rejected. So the way we calculate turnout refers to the number of people who have passed through that polling station in the 46,229 polling station in the Republic. We have not even reached the issue of rejected ballots or anything. It's how many people appeared that day. So we have a number. Then we do the counting. After counting, we get rejected ballots. So how do we determine 50 plus 1? We will say, okay, what are the total votes cast? And we will refer to the 2013 and 2017 decision of this court that said rejected ballots are not a choice of preference and the same have to be removed. So the idea that turnout is affected by rejected ballots or doesn't matter, it's just a measure of transparency. And you have to understand how the reporting of the Kims happens for you to be able to do. We only give what we can at the time, and we'll keep on doing that. With those
Thank you, Councillor. You're not even being heard. But thank you for answering our questions. On the kit, please deal with the registrar of the court. Thank you for your assistance. Your time is up.
And thank you. And the slides are.
My lady, I do not know whether you can give me 2 minutes to respond to Lady Justice Jokindong.
You're not helping me to do my day's work very nicely.
I'm sorry.
But 2 minutes would mean 2 minutes.
Yes, please.
So that you don't go away saying you are not heard.
Thank you very much, Deputy Chief Justice. The Honorable Justice Jokindong wanted to know from me of my personal experience as a draftsman of the original Constitution, what our intentions were when we created independent commissions. And my simple, straightforward answer is, we were trying to create greater autonomy and functional independence. You will recall elections, for example, were under the Attorney General's office and were under the hands of a person called the Supervisor of Elections, and that had been not very successful. What did we achieve? The one thing we achieved is that we created independent commissions that do not function in the same way. For example, this commission, the Electoral Commission, the chairman has executive authority, because this is one of the very few commissions where the commissioners themselves do some actual work. This is very different from EACC. EACC, the chairmanship is not executive, and the commissioners do not do executive work. They cannot determine to charge anybody or to investigate anybody. That is a work done by management. Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, Milady, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many, many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
We thank you, the Honorable, the AG, Senior Counsel. Thank you very much. At this juncture, I return this to the Judge President to lead the proceedings.
Yes. Yes, thank you for that session. We are really mindful of the time today because we wanted to finish these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Rengo.
My Lady, the Chief Justice, before the main petitioners commence their response,
yes,
there were issues raised by the bench yesterday on which we were requested to provide answers today. At what stage will we be able to do that?
I think it is now. We must have forgotten you.
Thank you, Madam. Just give me 1 minute, I get my notes.
Can we give you 5 minutes to do that? I remember it was like 1 or 2 questions which were directed to you.
Madam, the dilemma I have is that there were about 3 questions raised,
yes,
which I should respond to. But if you may recall, you had also permitted the advocates for His Excellency the Vice President to respond to the application by the Chief of Civil Service, Mr.
Yes,
Kenyatta.
that is correct.
And they did that, and we didn't have an opportunity to comment on their response at all. So I will try to be very, very, as usual, very quick and respond in summary, but I will need about 10 minutes.
Okay.
And my learned friend, Mr. Gratia, Senior Counsel, also tells me he has a request to make. Thank you.
Madam Chief Justice, you recall yesterday how gracious I was. I donated 32 minutes to court.
Are you claiming it back?
No. No, I will not do that because the court has work to do. All that I request is 5 minutes, nothing more than 5 minutes of your time. We are doing quite well this morning. Thank you so much. I don't know who will go first, whether it's my senior or ourselves.
I think you can go
first.
Okay.
Chief Justice and Deputy Chief Justice, members of the Supreme Court, just to point out that there were specific questions that were addressed. For example, to counsel acting for the 4 commissioners. And we would like to know at what point we are expected to respond to those questions. After the petitioners. Thank you.
Good morning, Madam Chief Justice and members of the court. I seek a little clarification because similarly we had several questions directed to us which we thought we would react to before we make our rejoinder. And I thought yesterday you had clearly stated that we'd have 30 minutes. We had about 27 questions. Are we at liberty to proceed to answer those questions right away?
Sorry, Senior Counsel Lengo, you have 1 hour to respond, but I hear you saying you need more than 1 hour because of answering the questions. And therefore you're asking for another 30 minutes.
With a little bonus.
We can see what we can do with 1 hour. If you extend maybe 15 minutes.
It would not be enough. There's a very important question which just...
It's all right, because even the time we are wasting now, you could be answering.
Yeah, so
yes.
in the 30
just
minutes...
asking you to be kind, because we really have to get to the real business
yes.
of writing the judgment.
Thank you.
And we don't have much time.
In the 30 minutes that we'll be answering those questions,
yes.
my lady and my lords, you'll be addressed by my honourable friend, Mr. Otiende Amolo, particularly on the question of turnout, which was asked by Justice Wanjala, and Firoz Norji, Senior Counsel, Paul Mwangi, and Ms. Julie Soweto will address you in those 30 minutes. And I invite Senior Counsel Otiende Amolo to address you on the first question.
Yes.
Not yet.
Yes, not yet. Not yet. Yes. Senior Counsel Oraro, please, or is it Gatti?
My senior is favoring my team.
Yes. 5 minutes.
Chief Justice, Deputy Chief Justice, distinguished judges of the Supreme Court. Actually 3 questions were asked that are relevant to our submissions yesterday, paraphrased as follows. 1, if the National Security Advisory Council 4 knew the results before they went there, and 2, why would the result not be announced the next day to build consensus, and 4, what would be the effect of the non-involvement of the 4 commissioners in the verification and tallying vis-a-vis Article 138(3)(c). Our response is as follows. 1, it is our submission that all factors point to an inescapable conclusion that the 4 members of the National Security Advisory Council, by the time they went to the Bomas of Kenya National Tallying Center, and by the time the head of public service placed a call on the returning officer of the presidential election, by that time they knew. And this is our evidence. By the morning of the 15th, letters had been issued by the returning officer of the presidential election, Mr. Chebukati, to all the presidential candidates and members of their family to be at the National Tallying Center for the declaration of results at 3 p.m. on that day. And my client already had received that invitation. I believe the other presidential candidates had those letters. And therefore, they knew by the time these state officers went to the National Tallying Center, they knew that the verification tallying had been completed, and what was pending was the declaration of the final result. It is our submission, Chief Justice, distinguished judges of the Supreme Court, that these four went to the National Tallying Center not for any other reason, but to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya, which had already been verified and tallied in accordance with Article 138(3)(c). 2, it is our response that the results could not be announced the following day because, according to the affidavit of the chairperson of the commission, and I'm using the word chairperson on advice by Justice Ndungu, which I agree with entirely, that by that time, it was not possible for any form of consensus, because then the follow-up question was, I think from Justice Lenaola, why, for example, the returning officer would not have waited for an extra day, which he had, to build consensus on the 4 walk-away commissioners. It was not possible. It was very clear that the intention was to try and veto the will of the people, and therefore the chairman had to declare those results. Number 3, the 4 who left, also their colleagues had been injured, and so the chairman had, in our view, make the announcement that day because of the gravity of the situation. Finally, the question that this court ought to ask itself is whether the walking away of 4 commissioners at the tail end of a process which they have admitted was complete, except the declaration, can veto the sovereign will of the people of Kenya. Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter? Thank you, and we prayerfully submit.
Chief Justice, my lords, Deputy Chief Justice, Lady Chief Justice, I'll begin with the question which was asked by Justice Lenaola, and that is, what orders are we seeking? The orders we are seeking is for this honorable court to dismiss the allegation by the second respondent on oath, which have not been accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act, and Article 183(3)(c), is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Wanjala, and you queried whether NSC, without knowing the results. My learned friend who has just appeared, invitations had been sent out, and the letter had been sent out. To the contrary, the evidence before you by the chairman was that he had gone to tally, to obtain the final tally only after he had met the commission, and that is found at paragraph 676 of his affidavit, where he says that after the NSAC team had left, the Commission Secretary, Chief Executive Officer, who was also the alternate team leader of the Tallying Center, Marjan Hussain, walked into the boardroom. Yeah. The purpose of the meeting was to receive the final tally of the results of the presidential elections before he could proceed to declare. And it is only thereafter that the results were handed to the commissioners and they walked out. So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left. Now, the Deputy Chief Justice asked about the effect of NSAC on the independence of IEBC. Your Ladyship, NSAC is a body comprised of all the heads of the security organs in this country, the head of civil service, the representative of Attorney General, and other heads in the government. Its purpose is to receive all the information on national security and give advice, not act, but give advice, so that even if they are of the view that it is insecure to be in this court at this time, it is the NSC who will give advice to the judiciary, and that is not an interference with the independence. And we have to take their role in the context that these 4 members of the NSAC were co-opted by the bigger body. They were not there on their own account, which has led to them now being vilified for undertaking an official duty they were requested to undertake. I had shouts from another friend on behalf of His Excellency, the Deputy President, of crucify them. In fact, this has indeed led to tweets today, and there are many, to various members of the NSAC telling them we shall revisit. This is what this type of allegation brings, and that is why I humbly request this court to look at the nature of the allegation, the burden on the people who are making the allegation, and dismiss them if there is no proof, and in my humble submission there is no proof, so that we discourage this political vilification on officers conducting their official duties. Let's be careful, and I humbly request particularly my learned colleagues on what we wish for this country. Let us not wish mob justice to be the arena of operations whenever various functionaries are discharging their duties. Let politicians do politics but let them leave professionalism to those who are engaged in various areas. In fact, since this process started, there has been a lot of vilification on the judges, on the parties appearing. In fact, tweeting has been the norm on discussing this issue instead of looking at it soberly. We can't stop tweeting. They are entitled to. But we can't bring it to this court. That's my humble submission. I beg that these allegations be dismissed with the contempt they deserve. My learned friend, Mr. Gatia, requests for donation of the 2 minutes to him, but I really would wish not to be so gratuitous.
Thank you. Madam Chief Justice, if you may allow me, I did not put one of our lawyers on record, Mr. Donald Kipkorir, who is not in court because of the sitting arrangements. But to come to the business before us, in answer to the questions, 4 of us will deal with all the questions that were asked by the court, beginning with my learned friend, Mr. Paul Mwangi.
Madam Chief Justice, Madam Lady Deputy Chief Justice, my lords, my ladies, I have 9 questions which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the count of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have 6-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, and our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioner case are taken on a JPEG format. And the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, in the affidavit of the second petitioner, Martha. And in that flash disk, there are two incidences at the National Tallying Center. In one incident, Commissioner Justice Nyang'aya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniora Cherere. Again, she is given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the IEBC, is a person who has qualifications similar to be the Supreme Court judge. So it is him who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the four commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile three theories. One is the issue of the 89th minute penalty, that if you participate in a game and the wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at it, it is an issue that is understandable. The other question is in regarding for if there were to be ordered an repeat election, who would conduct it? Would go back to Article 250, Subarticle 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, in inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there's a jurisprudence that is being built that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the IEBC from any duties because there was no agent. And in fact, one of the advocates, like Kent, said that you must have agents in every place, and even likened to agents. I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism. Their courts must restate the duty of IEBC to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Maha did, I want to show the court a Form 34A from a place called Gasharaigo Primary School, and it is in Moranga, in Kangema constituency, in a ward called Murugo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of IEBC. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Jose Camargo, and we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.
Good morning, my ladies and my lords. I will pick up from where my learned colleague and senior Mr. Paul Mwangi has just left off. The court had asked that we demonstrate with examples in real time how the Form 34A was interfered with or could be interfered with. And I will do so showing you or using the IEBC's forms itself, straight from the IEBC, from the IEBC portal. My lords and my ladies, I will walk you back through the form that we have just showed you. I see that the court has laptops, which means you're tech savvy, and you can access the IEBC portal right now. This is going to be a live demonstration, as the court asked that we do. I'm asking that we go to the forms portal in the IEBC. We are projecting it up so that it's not said, because we have been accused of cooking things, forging things. We've been called many names. This is the IEBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County. Kangema, Moguru, and Gasharaigo, Primary School 02. This is live. My lords and my ladies, we have downloaded a Form 34A from the IEBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IEBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. Now, my lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Mwaure Waiga, 001. And the last is Wajakoya, 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. They did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? What are you doing? This person is the one who was interfering with the forms. We are able to demonstrate, at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
you let her finish and then you tell us what it is they're responding to.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
And it's not the IEBC.
My ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition. And is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IBC live portal to show how the staging was happened. And because of time, if we can go to Bungoma. We want to do it live, and we're doing it live on the IBC portal. My lady, we were told about the KIMS kit and how they work. The serialization of the numbers. We have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyiwa. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates, and then it will show you the Kim's kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Now, the serial number on this particular form, my ladies and my lords, which I would have liked for the court to confirm for itself, if somebody there can, may I ask one of the court assistants to read for us the serial number as it is, so that then I'm not accused of making up things?
That's all right. It doesn't change anything. Evelyn, could you read that?
The number that starts with F2, it's in the middle. Or can I read it myself?
I can't see it. The one on top?
Yes.
PR06.
No.
Oh, sorry. F2.
My ladies and my lords, what would require is that you note down that number. We will compare it with another later.
It reads F2 3045 0M 00204 133.
The time, please. It's right next on the date.
That one. The time is?
The date on which?
9th August 2022 at 1956.
We'll check another form. Nyeri? Nyeri Town? Gatitu? Morogoro? Tunguma Primary School? Stream 3. Can you read the serial number?
F230450 M00204133.
And the date and time, please?
9th August 2022 at 23:49.
My ladies and my lords, this is the same Kim's kit transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri Town. 2 hours later, how is that possible? When each Kim's kit was supposed to have, each polling station had its own unique Kim's kit, which was supposed to transmit from its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KIMS kit was required to have its own unique IP address. The only way 11,000 KIMS kits or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I have, I beg your pardon, my time is up.
Yes, 2 minutes.
Yes. My ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IEBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IEBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much. At the insistence of my seniors.
May it please the court, my name is Kirago Kimani. My learned friend, Mr. Katua Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have directions.
Mr. Kirago.
Yes.
When I forget his name, Mahat was answering the questions, he did the same.
Yes.
He went through his PowerPoint.
That's correct.
To demonstrate.
That's correct.
How this staging was happening, because we asked that we be explained.
Yes.
How the forms were being captured in the hair and being changed. And he did that.
Yes.
Going back to what he had done.
Yes.
So what is new here?
What is different is this. You have a petitioner and you have rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate how this was happening.
Yes.
What we do with the demonstration. Mr. Mahat on your side did demonstrate, they have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this match, not for us, but as required by the Constitution.
Mr.
But anyway, the long and short of it, yes.
I'm
the long
sorry.
and short. Yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. I'm beginning with number 1, the same order we followed. You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Leadership, Madam Deputy Chief Justice, my lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I had donated, I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner, in number 1, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission.
Okay.
That's what my entire petition is based on.
So then we start with the main petition,
that's
their
fine.
Rejoinder, then we
That's
come
fine.
to you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Olengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Mutata.
They will respond with their rejoinder.
With the rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Murgor, and I'll have 5 minutes at the end. Okay. But I'll begin with Senior Counsel Otiende Amolo.
If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Nkuli, says it was 56.17 at that same time, looking at the same Kimskit. It will be noted by this honorable court that at various times, the IEBC gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IEBC proceeds is wrong. and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, Your Ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IEBC did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Keme's kit, the figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Keme's kit, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, Your Ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Keme's kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the Keme's kit, and all 42,298 Keme's kits failed, and only one in one polling station functioned, then it means that if the 700 voters in that polling station voted, the IEBC will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. That cannot be. The voter turnout cannot be something that depends on the interpretation of the IEBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IEBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. we wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IEBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, Your Ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, Your Lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IEBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, I address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the, even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IEBC. The verification has to be done by the IEBC. The declaration decision has to be made by the IEBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. Is it the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so the coup was all right. And so my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But it is a very dangerous thing, not only historically, but because Professor Kindiki revealed, perhaps unknowingly, that we now know that the doctrine of necessity has been discussed in their private thinking and now is brought here publicly. And when there is, next time, there doesn't have to be a chair and 3 people and 2 policemen clearing the chaos. Next time, when there is a manufactured group assaulting another group, of 50, 100, 200 people? Who will get up and say, we have taken power as an act of necessity? Because our attempt to do so at Bomas to establish a new government not in compliance with the Constitution failed, as it should fail. But now, with the doctrine of necessity, we are there. And we will take on anybody who says that we are doing anything wrong, because the doctrine of necessity requires that we restore peace and order and move on. And then when we bring the matter to court, learned Professor Kindiki will be here to say, I will now refer to the case of Mandus Butiro, South Rhodesian law reports, and say, here it is. Here is Pakistan. Here is the case from Uganda after the Uganda coup, applying the same thing. And we say, this is the prophecy that is put forward now in their thinking, shown unwittingly, I think, by Professor Kindiki, and placed before the people of Kenya. We say, not only reject it, but reject it consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that again from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court, and he said, let us get at the substantive truth. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chebukati used, was illegal because in the Gazette notice he lied and put forward just half of what the power he has needs to meet. And so when we put these forward, they could not reply, but those who attempted the reply said, but look at this. This is his power, this is his this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment of the Regulation 67, by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the IEBC Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office. and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened? What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government. Finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the respondents' counsel or supporters, or by any reference to instructions, that these values we kept in mind. This is how we advance. By postponing Kakamega, this is the value we advanced. By not checking the wrong printing of the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to the court that not only is the petition, we pray, to succeed, but very importantly, if you find that there is violation of the Constitution by the chairperson, it is not necessary for the court to take any steps to his removal. There is a constitutional position. Thank you. There is a constitutional process to remove him, and there is no need for the court. But there is an important duty on the court that if you find a serious violation, and we submit there are all these serious violations, it is important that the court makes a finding. We hold that, or we find that the chairperson violated this article or that value, and that those are set out. We pray accordingly. Thank you.
Having just come in, good morning, Your Ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record that and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the IEBC. I, at that point, did ask whether he's an employee of the IEBC, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the IEBC. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by IEBC. So it's not, does not lie in the mouth of counsel belatedly briefed to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the results from the polling station was between the 9th and 14th of August tallied 137,000 times 847, 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times, 574. 11th, 16,291. 12th, 8,357. 13th August, 14,357. 4th August, 24,000 times, 897. This shows that numbers, the same numbers, were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise, the scrutiny exercise, and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then
stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that the evidence that has been presented by the petitioners shows a well-orchestrated and fraudulent scheme that was executed with military precision. Let me agree with my learned friend, Mr. Mahat, on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James Ray.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity? We don't require more than 3 or 4 minutes to indicate that what the court was shown is not true. Because otherwise, this image is now all over the country, a sensational image about forms with the names of people, whereas in truth, that is not correct. All that I would request, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played, those are not polling stations in the petition, it's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth.
What we are doing, and then at the end of it, we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lady, my lords, when I used to be at Alliance High School, every year, Professor Giddu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense? Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your lordships, some of the advocates who are in that petition, acting for the respondents when we presented our petition, said that what we presented before the court was a science fiction. And I'm not surprised that even at the beginning, and it's well covered in the media, that what we have presented before you is fiction. And because it is fiction, you had a lot of speeches which I think do not belong to a courtroom. They probably should have been delivered in some theater where people love poetry, like my learned friend, Professor Giddu Muigai, whom I know, having attended the same school as I did, we share a lot of things in common. we have presented before your lordships a petition based on averments which are contained in the petition. We have placed evidence before your lordships, and the petitioners did not ask the petition to be struck out. Instead, they filed volumes and volumes of affidavit evidence, and I've addressed you at length on matters relating to the petition. And yesterday, I remember when your lordships and my ladies asked questions to the respondents, my learned friend, Mr. Gidu Muigai, said those questions were difficult questions, but they are not as difficult as the questions which were directed against the petitioner. But having said that, there is an important point about this new constitution. And I'm so happy that your lordships and your ladyships, some members of this court were part of the process of drafting this constitution. And my lady Justice Njoki asked a question which was very pointed. Why did we create these commissions? Why did we create these independent offices and secure their tenure in the Constitution? And the answer is that we are dealing with an imperial executive. The commissions became an insurance policy for the protection of the sovereignty of the people. And if you look at Article 249, the commissions and independent offices are required to protect the sovereignty of the people. And what better tool to use in order to protect the sovereignty of the people than to have fair and free elections conducted by an independent body. And this constitution requires that the elections must be transparent, and they must be administered in a neutral, efficient, accurate, and accountable manner. I would have hoped that if the Electoral Commission was indeed carrying out an election that was free and fair, transparent, and accountable, they will be offering all the evidence, including what is in the servers, that this is what went on, this is the record, this is the return of the elections that were held on the 9th of August, 2022. I thought that we were making progress. Your lordships and my ladies, there was a time that we used to file petitions against even the President of the Republic of Kenya under the old constitution. And if you approach the Electoral Commission before you file the petition, you had access to election documents and election materials before filing the petition. And I did that so many times. My learned friend Firoz Norji would tell you, because I was a petitioner. And he filed such a petition. Now, to get information from the Electoral Commission, even after filing a petition and an election has been conducted, is like the road to hell. Because that's what it is. And in Article 249, the sovereign, who is the people of Kenya, require of the Electoral Commission as a state organ to secure the observance of democratic values and principles and promote constitutionalism. Not just in the conduct of the elections, but even the way it runs its affairs. They cannot pretend that they are conducting elections and valuing and securing the principles of democracy as contained in Article 10 of the Constitution, and yet within the body itself, they don't value these principles that are not discretionary. They are, every state organ, every person is required to act in accordance with Article 10. What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions? In the Electoral Commission, instead of having a commission of 7 commissioners, and you have seen the factionalism here, you have a triumvirate, you have a trioca that is moving together all the time with the secretary of the commission. This is not what the Constitution desired or contemplated. If you look at Article 88 of the Constitution, the mandate of the Commission in relation to the supervision of elections and referenda, at the end of that Article 88, and I think this is important, sub-Article 5, the Commission shall exercise the powers and perform its function in accordance with this Constitution and national legislation. So that where the chairperson comes before you and does not show conduct that is in consonance with the Constitution, is that a matter that this court can just gloss over? When the Constitution says in Article 2 that this Constitution is the supreme law of the Republic and binds all persons and all state organs, and no person may claim or exercise state authority except as authorized under this Constitution. And throughout that Article 88, the Constitution throughout talks about the Commission, except in 2 instances, one of them being the declaration of the results in a presidential election. So I urge my ladies and my lords that where there's been an infringement of the Constitution, however good the outcome, but there has been an infringement of the Constitution, because the Constitution says how we should conduct elections. It does not matter whether you get 10 million votes or 20 million votes. If you get it by murder and killing people, if you get it by falsifying documents, however the numbers you end up getting in an election, that would not be the kind of election contemplated under Article 81 of the Constitution. The process matters. And anything in violation of the Constitution, if you look at the Constitution broadly, any infringement of the Constitution, violation of the Constitution in relation to state officers, including the President, including members of commissions, any infringement of the Constitution normally would attract consequences of removal, impeachment, because it's a matter that this Constitution frowns on. And that's why I always appreciate the fact that this Constitution requires of citizens, every person has an obligation to respect, uphold, and defend this Constitution. This petition is in defense of the Constitution. Is in defense of the Constitution because there's an election that has taken place that is putting somebody in office, or is attempting to put somebody in office without meeting the requirements of the Constitution, not only in terms of, not only quantitatively in terms of votes, but also in terms of what the Constitution requires the conduct of elections to be like. And the Malana Senior, Mr. Firoz Nerji, referred to a football match. These days, football has many rules, and they keep on improving. However many goals you score, if it is from an offside position, whether you're Messi or Ronaldo, it will not count. It will not count. So I urge the court, and I am an optimist. I think we are doing very well in this republic. I think we have come from very far. And as one who has practiced in these courts, when things were extremely difficult, I know we are making progress, a lot of progress. There were times to file a petition like this was not easy. And if you file it, serving that petition will be very difficult. And that is not just because of legislation and a new constitution. The courts had made an intervention many times to protect the people against those who govern them, particularly. I therefore invite your lordships that looking at the article dealing with leadership and integrity, what has been placed before you is not a matter that the court can frown on, gloss over. This court said in 2017 in the Raila petition that if the Electoral Commission comes before you with the same kind of infractions and transgressions, this court will not hesitate to take measures against the Commission and its leadership. That is in the Raila judgment of 2017. In 2013, this same Commission, fortunately for the chairperson, he was not there at that time, despite the fact that that petition was not allowed, but the court was not amused by the going-ons in the Electoral Commission. And by dint of the comments that were made by the court at that time, at least a few people were taken to court, although that case is still going on. I think this court, and reading the Supreme Court Act, Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes, and principles of this Constitution, and contributes to good governance. So I urge this court, with all the humility, that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at IEBC to go without some kind of action in the lines that was suggested by my learned senior, Firoz Nerji. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. and arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election? And that election have some legitimacy to the people of Kenya and to the world. Secondly, and this would be my last point, that if you look at Article 138, sub-article 4, and my learned friend Mr. Otiende addressed you on this, that requirement for a successful candidate getting 50% plus one of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation and put the numbers before you in rebuttal to the case that we have put before you. My little friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the Kimskits do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign, and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.
Your Ladyship, Madam Chief Justice, Your Ladyship, Madam Deputy Chief Justice, Your Ladyship, and my Lords of the Supreme Court. The petition that was filed by the first petitioner, to recap it, was a very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the IEBC Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. It appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship was there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. But here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists, the ones, the protagonists of We've Won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it was in the McFoy case. It's an English authority that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously. They didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see is that this, by the law, by Article 138 3C, it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show, surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called Raila, which was Raila 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter, and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words, because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kirika.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions clearly said 30 for us. Youth Advocacy.
I don't know whether there was any question directed to you.
Yes, there were. But the direction said 30.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes.
Yes.
I think the clock said 15.
Yes.
I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel.
Yes.
For our record.
Yes.
Introduction.
Yes, Your Lordship. My name is Tom Asharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you are treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Ndwati. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level, where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tier was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the IEBC online system for purpose of tallying from all original forms was correct. In case the data entered in the IEBC online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of IEBC was told in the minor KI case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KI. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KI, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 polling stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the County Tallying Center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Minor KI put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, Maina Kiai was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority, this court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the 3 levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairman of the appellant. Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him. And the only reason he would then have proceeded in the manner that Veronica Nduati tells us is that, to use another Kenyan phrase, mtadu, what are you going to do about it? That is the only reason one can find for what he did. Yesterday, the commission came and told you that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at 3 levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the Commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiko Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Mwololo. Same problems. He has 2 forms. 50% of them, which is 1 form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what my Nakia has said and what my learned seniors have said here this morning, my mind is taken back to a few months ago, when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1544, 1535, and 1500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the IEBC has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate, the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. Our learned senior, I think Mr. Orengo, I think it was Otiende Amolo Senior Counsel, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend, Mr. Morogo, has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette notice does not improve it. But perhaps more importantly, If it meant nothing, why publish it in the first place? If it meant nothing, why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 constitution, we keep pushing these things away to the back of our mind. And people go to campaign, the rest of us go on with our lives, and he publishes a new gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be an usher. These are slowly and then progressively, we end up with what was this morning called an imperial chairman of the commission. And so this is how we ended up at this unhappy day, where 4 commissioners say that we cannot stand by these reasons because we were not involved in everything that was done with them. But apart from that, and apart from those obvious misdemeanors and indiscretions that have been pointed out here this morning and the day before yesterday, in our petition, we've raised the fact that even other statutory requirements, the KPMG audit report, for example, was only published on the 5th of August, 4 days to the election. And parties kept asking for this report. Why is the report? And we'd all be told, again, in that most Kenyan fashion, tunashughulikia hiyo maneno. So you go back and campaign, go do your things, and you wait. And on the 3 days before the election, it is dumped on the website, and no one is actually told. There was no press release saying, we've released KPMG now. We had to find it there by accident. Now, when you finally go and look at that report, and you'll see a copy of it in the particular pages I refer you to, pages 1,153 and 1,155 of the year petition, you will find that KPMG complains that both the Commission and Smartmatic withheld critical information as regards how the voters register was being accessed. And that by the time the report was written and released, they had not received that information. That was the KPMG report. Now, again, the Commission comes here this morning and tries to explain to you how they arrived at the question of voters identified with the printed register. One of the things you will not find in the affidavits filed by the Commission is an account of how many Form 32As were signed as required by law. And that is the only mechanism that the regulations identify for identifying those who have voted outside the Kim's kit system itself. And so what they've done, and that's what I think one of the honorable judges yesterday called a bit of a lecture here yesterday, is do reverse mathematics. You begin by adding up all the votes you say were in the Form 34C, and then you subtract from that those who were identified using the Kim's kit. You have not been given a report of how many Form 32As were signed. In addition to that is the tortured question of Regulation 69, Subregulation 1A, and I've not had anything said about that here. Now, Regulation 69(1)A of the Election General Regulations requires that every time a voter is identified using the Kim's kit, the printed register must be crossed out. And this is not a function of voter identification. This is an audit tool to ensure there's no fraud. A distinction must be made between what was before the Court of Appeal in the case raised before you about the printed register and what the law requires as regards the crossing out. For some reason, the Commission strenuously opposed this audit tool. Now, you've been told that there were approximately 92,000 stray ballots. Now, the mathematics that the commission chair uses to arrive to that number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition, is taken two constituencies, this is Makadara and Kibra, and said that in those two constituencies, we had an average of 2 stray ballots per polling station. They take an average. And the reason for this is that it is not possible to account for stray ballots in Kenya within the time that this court must rule. Because under Regulation 81E, once stray ballots have been identified, they are put in an envelope, and neither Form 37B, 38B, or 39B have anywhere to indicate stray ballots. They are indicated in a polling station diary. The only way of arriving at a precise number of stray ballots and identifying to whom they strayed, if I may use that word, is to audit the polling station diaries for the 46,000 polling stations in this country. And that hasn't been done. And so we can't speak with any certainty here when a figure is thrown at this court that there are 96,000 or 92,000 stray ballots. No one knows. The truth is that no one knows. That's number one. The second thing is that in arriving at these mathematics, the chair of the commission says that in six polling stations in Starehe and Mathare, the officer locked up the forms in the ballot box. And he then says that in the 6, we cannot account now for 4,200 ballots. Now, 4,200 divided by 6 is 700. What he's saying is that in those 6 polling stations, there was a 100% turnout. You will see that at paragraph 74, 75, 76 of the replying affidavit. Now, when you go to the forms on the portal, as we've been asked to do, the turnout is not 100%. And so that is a false averment in his affidavit. I think much has been said about the forms and the PDFs. I think I won't venture to say anything about that. I think I should also state, because it was part of our petition, that by the time we went to the election, and I think as of today, an audit report as required by the elections technology regulations has not been provided or done. It's not on their website. It's not been provided. The elections technology regulations under the Elections Act require an annual audit under Regulation 10 and 11. You will find in a response by the chairman to the first petitioner's party a letter where he says we could not do the audit because we did not have money. He has now annexed, in response to our petition, a certificate, a 2-page certificate, where they say we have 10 reports, but he doesn't attach those 10 reports. They are not on the website, and we have not been provided with them as of today. The purpose of that audit is that it might become impossible or unnecessary for us to spend time here discussing things called logs. And the only logs my grandmother knows are those she uses to warm herself. And yet she's the voter. We must, and I think we've submitted before you a case from the German Constitutional Court, which states that unless the public is able to, independent of an expert, audit the process used to conduct an election, then that election is not verifiable. That decision is before you with our digest of authorities. And it speaks to something a bit more nefarious, if I may use that word. We have just been told here today that we had foreigners who have accessed our IT systems. I can't pronounce their names on account of my county of origin. Now, and what has happened is that, and the submission I would make, is that the IEBC ceded control of the process of determining the sovereign will of the people of Kenya to a foreign entity that now says that that data is the intellectual property and cannot be shared with Kenyans. And there are very, very serious questions that arise. And I say this because they were asked of the chairman of the commission. For example, this data, they now say is theirs. Has it complied with the Data Protection Act? Was this company subjected to the provision of Section 31 of the Data Protection Act? And what are the consequences of surrendering our data, our biometric data, to foreigners who now tell us that is now their intellectual property? And I think Kenyans would be forgiven for saying that we're going soon to have leaders made in Venezuela, not in Kenya, not by Kenyans. Allow me to use the few minutes left to address some of the questions I think you raised, especially as regards remedies. But before that, let me just point out that amongst the other failures by this commission was to provide the Parliament of Kenya with amended regulations, which they promised to do last year, but presented amended regulations in June or July as Parliament was going on recess Sendai. And so again, they'll come and tell you the law was not amended for us to rectify some of these things, but they submitted their proposals late again and outside the election operations plan that they had said they would do. Now, printing of ballot papers, a specific question was asked of them. This company that you have procured, rightfully or wrongly, is accused of having led to the postponement of an election in Nigeria. And the chairman again said, there's no problem, tunashughulikia hiyo maneno. On the 8th, we have the largest postponement of elections in the history of Kenya. The elections postponed on 8th August was the largest number of postponements in the history of Kenya. So what should we do? Kenyans who run into problems and who find complicated issues they don't know what to do with, I always want to say, do something. Can somebody do something? Somebody should do something. That is what we say. But this honorable court has the power to do something. And it has power to do something even in the face of an imperial commissioner, chairman of the commission, who quite casually says, Mutadu, do something. You have power under Article 140, and again, in my view, I think the question was asked here about the utility of Section 80, subsection 4 of the Elections Act. Now, I think given the time limitations that this court has to do a recount and a retally properly, that section is one that is not very helpful or useful. The requirement of the Constitution under Article 140, sub-article 3, is for a nullification of an election that is found not to have been in compliance with the Constitution. That is number one. Number two, I think the judges asked of us, what is to happen if we are to then find that this chair violated the Constitution or committed crimes? Again, that is a question that has risen here before. I think in 2017, we have an Election Offences Act. We have Article 251, which make provision for what is to happen to errant and imperial officers, public officers, such as the one whose case is before the court today. And so I think it would be premature to start anticipating what were to happen, because I think our Constitution has sufficient, and I think we must trust it. We must trust our Constitution and the mechanisms it has created under Article 140 and other articles for what is to happen in that eventuality. Madam Chief Justice, Deputy Chief Justice, I want to thank you for the privilege of your attention. And unless there are any questions left for me, I will donate my 1 minute back to the court. Thank you very much.
Thank you. 15 minutes given to the fourth petitioner, Khalifa.
My Lady Chief Justice and the court, may I plead with the court once again that what we are listening to is not a reply. It is a rehash of the case afresh, and it is leaving us in a very vulnerable position because new issues are being raised, and we have had or may not have, unless you assure us, my lady, that we'll have an opportunity to reply.
I think we have already cautioned counsel to reply on points of law, and you can see all of us are busy. We know what are points of law in our reply, and we know what we ignore.
This is only 2 seconds. You said that earlier. We all thought we had. Despite that, Mr. Mashari has taken 30 minutes to argue factual issues, going to affidavits, nothing on a point of law that he responded to. In my submission, therefore, the court will be perfectly entitled to disregard every word he uttered.
Yes, we know how to separate the chaff from the wheat, from the submissions. Yes.
My lady, before I start my submission so that my time doesn't run, I find myself in the position, I'm Willis Otieno for the fourth petitioner, in the unfortunate position that I'm one of the most mistreated petitioners in these proceedings by the first and second respondents. They served me late, as I indicated already during the pre-conference, and we lost the opportunity to respond. And this court did indicate that when we'll be doing our response, we can comment on some of those issues. We never filed a rejoinder to them because we were the ones who were served late outside the timelines provided by the court. So, but I don't intend to go deep into facts, but I may make one sentence references just to meet what had been allowed before, if that is in order. Number one, my lords and my ladies, we must assert that the KPMG report, the only expert report that has been done on the biometric voter register, that evidence has not been challenged by any other expert evidence. And that evidence which we annexed and referred to, we can now safely conclude that the 481,711 deduplicates that are in that report, 481,711 is admitted. The second point that I wish to respond relates to the question my learned senior Professor Gidu Muigai said, that if these elections were badly conducted, not in accordance with the law, what about the other 5-tier elections where we have governors and senators? One answer, jurisdiction. Every court will have its day, every court will consider the facts of those cases. The third point that I wish to respond to relates to what was asked of when the regulations that gave the chairman the power to be a returning officer were passed, they were law at the time he acted. Simple answer. Maina Kiai case had already answered that question of what the law was. Maina Kiai case had interpreted Article 138(3)(c) of the Constitution. That was the law, and any regulation being made to circumvent that law by itself is unconstitutional. As I said, Helef was a petitioner in Maina Kiai case. Helef came to court. Helef has come back to court to enjoy the fruits of his litigation in Maina Kiai case, and I was his proud lawyer in that particular case as well. My lords and my ladies, reference was made that the IEBC saw the ballot boxes for the first time that necessitated the postponement of the elections on the 8th of August. My lords and my ladies, Lycos never disappoints. You've just been told how Lycos, wherever they printed ballots, they've always ended up with postponed elections. IEBC should have exercised due diligence to make sure that even the pre-printing images are cross-checked and confirmed to be accurate. An admission that I submit is that IEBC was not diligent and it must pay that penalty. It cannot transfer the consequences of their lack of diligence on the people of Kenya through fake elections. My learned friend, Mr. Gumbo, spoke on technology, and he gave us the Kriegler report. Kriegler report did not say deploy weak and vulnerable technology. Kriegler report required you to deploy sufficient, efficient, integral technology that protects the will of the voter. Kriegler report did not make a recommendation for Jose Camargo, Diego Maradona midfielder, to sit in the middle and start distributing results, as was demonstrated today in the morning. Kriegler report is not an answer or does not excuse a technology that the KPMG audit report has found and confirmed to be vulnerable, has 14 unauthorized users called Embakasi South cracks. The fourth point I want to raise is IEBC has confirmed that we look at the portal to tally the results. It is not the public portal that is used to tally. Tallying is a function of the commission. The commissioners must perform a tally of those results. And what is the commission vis-a-vis the secretariat? I refer this court to the case of Engineer Michael Kamau versus EACC, where the court specifically said the core functions of a commission cannot be performed by the secretariat. That was the Court of Appeal decision. It's part of the bundle of documents that we've annexed. You are told, my lords and my ladies, when in relation to the question of how integral the technology was, and my learned that Justice Lenaola did ask, when you take a JPEG and it comes out as a PDF, and I tie it to the response, what Camargo was doing in the system, and my learned friend Samane said, he's a plumber. He's like a plumber maintaining the system. Let me say this. Once a plumber has fixed your bathroom, that plumber has no business being in your bathroom when you are showering. If you find him at that time, you tell him, get behind me, Satan, as was said in the book of Mark 8:33 in the Bible, when the devil entered Peter, and Jesus told him, get behind me, Satan. A plumber who is in your bathroom when you are showering after fixing your shower is no longer a plumber, is a sexual offender and should be reported.
Let's stick to the
I'm guided. Mr. Somane took you through several forms, explanations, trying to explain what is voter turnout, the Kim's kit. At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, are those results, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi? It should be simple, accurate, and verifiable. What we've been shown is not simple, is not accurate. This court is still left with so many questions as to the true Kim's kit logins, as to the true and exact turnout of voters as at 5 p.m. on the 9th of August. You are told that parties must have their own agents to present things here. My petitioner is not a political party. He is not a candidate, but is a voter entitled to participate in elections and to present a petition. The obligation, legally speaking, is on IEBC to provide a free, fair, and verifiable election. There is no obligation on a voter like Hele Khalifa to hire and recruit agents all over the country to watch how the elections are conducted. If you do so, then you will forever relegate the participation of the people of Kenya in a free and fair election to the ability to hire and deploy over 46,000 agents in all the polling stations to watch over their vote and the votes of others. The question was asked, the question was raised by Mr. Ngatia, that election officials are tired, they need to go back to work. Convenience again. I say this. Our constitutional values and provisions should not be sacrificed at the altar of convenience. If the election officials are tired and cannot do another election, please, we have more Kenyans who are willing to do this work properly. Give them that opportunity. And that ties to the point that was said, that Kenyans cannot be in elections in perpetuity. Kenyans must get it right. And I say this with due respect to this honorable court, that the Supreme Court has a higher obligation when it comes to this issue, to ensure that we get what we call regime legitimacy. In countries like DRC, once a presidential election is concluded, it goes to their Supreme Court, the Constitutional Court, to get a validation, regime legitimacy. That is what HELEF is questioning here. In a fractious society, highly political like this, just remove that, highly political like this, a Supreme Court's decision gives regime legitimacy to that new regime. And when questions are raised like we've done, then the Supreme Court, and when you consider the margin by which the purported declared winner has surpassed the victory, that legitimacy should not be granted by this court at this point. I want to address a few questions that were asked by the learned judges. Number one, by Justice Ibrahim, is there a lacuna in the law if we nullify, in God's grace, these elections? And, sorry, if we indict Wafula Chebukati? The answer is very simple. Article 142 of the Constitution, the president who is in office shall continue in office until a new one is sworn in. There is no lacuna in the law. The second point, Mr. Chebukati is not immortal. He could even resign from his office. Does it mean that this country can collapse if Mr. Chebukati resigned from his office today? No. Elections will still be held. We'll still have within our governance, we have a working parliament, we have a national executive, we have a judiciary. All these questions, all these issues can be addressed within those existing parameters. And when I say the president will continue in office, of course, within a narrowed mandate, but the systems and the functions of government will continue. The lacuna will not affect the people of Kenya. The right thing is to make sure that the people's voices are actually heard in a true, transparent election. My learned Chief Justice asked the question, why it took too long, why the Commission did not announce the results from morning. To corroborate that there was actually peace at Bomas, we had a choir singing the whole night and the whole day. If there was violence as was being presented here at 3 p.m., what stopped them from announcing at night those remaining polling stations, constituencies? What stopped them from announcing those constituencies in the morning? The choir is my witness. They were singing, there was peace, and everybody saw that. The other question that was asked by learned Justice, Deputy Chief Justice, about a dysfunctional commission, I wish to say this. The dysfunctionality of the commission has always been there. But it has been brought to us by what I call a celebrated group in this constitution. In 2007, Kipkirui, an individual clerk, came out and told us what is happening at KICC is cooking. In 2017, Rosalind Akombe came out and said, what is happening at IEBC is not being done in compliance with the orders of this court. And she ran away, she fled this country. In 2022, you now have the commission itself, by a majority of its members, coming out to tell Kenyans that what is being announced are not the product of the commission. Should those commissioners be vilified? Should a commission that has made an admission of a failure of Tier 3 be vilified? I say no. That dysfunctionality should actually now prove to you that indeed the Constitution is working. On the question that I wish the court to consider, what would have happened if we didn't have this court? In 2007, we didn't have this court. And those who had been said to have lost the elections didn't want to go to court when they were asked to go to court. Because to serve a president was almost impossible. The hearing of the petition will have taken forever, even 5 years, the entire term. This court should not leave Kenyans in a way that they start questioning themselves, do we still have an avenue through which we can solve these political questions? That is a core function of this court. If the court fails to stand up to occasion, the ramifications on the people of Kenya will be dire because people end up losing trust. So I urge you that do not err on the side of convenience to tell the people of Kenya that when we can see some of these problems, convenience requires that Chebukati cannot conduct an election within 60 days. Let us not upset the elections. It will erode public confidence in this particular court, which will be catastrophic as we witnessed in the year 2007. Tied to the commissioners, there are affidavits, and I believe the commissioner will talk about them. In their reply, the majority commissioners in their replying affidavits have already, we must point out, number one, that these commissioners have been in office for less than 1 year. September marks their first year in office. Within that 1 year, they've filed they've written 3 memos on the conduct of the chair unilaterally making decisions. Ultimately coming out on the 15th to tell Kenyans what they had been dealing with internally of a unilateral, arbitrary, all-knowing chairman. And I say this as I conclude, my lords and my ladies. When an alligator comes out of the water and tells you that the crocodile is sick, do you doubt him? When the commissioners come out and tell you that our processes are opaque, our processes are not as per the Constitution, do you doubt them? I urge you, don't doubt them. We pray, my lords and my ladies, that you allow the petitioners prayed and grant the orders which are sought, and don't shy away if you find it necessary to indict Mr. Wafula Chebukati for the transgressions and the singular manner in which he has run the IEBC to the detriment of Kenyans. Thank you very much, my lady. I yield today 13 minutes of my time back to court. 13 seconds.
Thank you. Counsel representing the fifth petitioner, David Kariuki-Ngare. 15 minutes.
Your Ladyship, the Chief Justice, Deputy Chief Justice, members of the court, may it please you that my name is Mamboleo. I represent the fifth petitioner in the consolidated petition. We will be making this rejoinder together with my learned friend, Mr. Morara Umoke. Your Ladyship, when we filed this petition, the response we got from the respondents was that this petition was frivolous. The other response, my ladies, my lords, was that the tallying, verification, and declaration of results at the National Tallying Center is a preserve of the chairperson of the commission. That the rest of the members of the commission have absolutely no role whatsoever. I can quote my senior colleague, Mr. Kamau Karori, as deliberately insisting that the other members of the commission, the 6, don't have a role. That in fact, the chairperson of the commission has been extremely magnanimous because at various points in this process, he's even involved them somewhat. The third response we got is that the election of the President of the Republic of Kenya is just about numbers. It is numbers, numbers, numbers. And then lastly, the respondents wanted to put this court in a dilemma, a catch-22 situation, by suggesting that should they exercise some powers under Article 140 of the Constitution and probably nullify the election, we are going to get into a situation that is uncharted constitutionally. Create fear. Your lordships, your ladies, I want to suggest to this court, when you retire, to look at what we call the theory of false dichotomy. The theory of false dichotomy is an informal fallacy that is based on a premise that erroneously limits the options that are available. And what the respondents are telling you is that the Constitution does not provide mechanisms to deal with the situation that might arise for something that is expressly provided for under Article 140 of the Constitution. I also want to suggest to you, my ladies, my lordships, when you retire, to look at what came into the open about 3 years ago, which is called the CIA Rulebook on Disruption of Organizations. How do you disrupt organizations so that you do not have an organization working as it should? And when you have achieved that, then you come out and use the law to subvert the will of the people. On Bomas on the 15th of this month, of August 2022, it is now judicially noticed that the beaming of results stopped. It is now in public notice that commissioners of the commission, at least for them, came out and stated that they do not have anything to do with the result that was being announced. It is actually admitted that as this was happening, top in the mind of the chairperson of the commission, he knew and understood the process of tallying, verification, and results to be his own precept. He's not even refuted it. He says that is how he understood it. He said that the other commissioners had no role. So what do we want to suggest to you, your lordships, your ladyship? It is a very simple thing. That the reason why Kenyans were so glued to the television sets for almost 6 days is because the election of president is the only one thing that Kenyans do as a collective every once in a while. It is so important to them that you simply cannot joke about it. The reason your lordships and every Kenyan was glued to media stations for the 6 days is because you wanted to know what happened to your vote. So Article 138(3)(c), as read together with Article 38 of the Constitution, is, in my view, an expression of the greatest protection or the greatest gift that this Constitution has given to the benefit that is promised in Article 1 of the Constitution, that the people are sovereign. But if somehow you manage to capture the sovereignty of the people and set it aside by some scheme or something, then we are in a problem. And without taking too much time, because I associate myself with the submissions made by my learned senior counsels here, the important thing that we want to suggest to you, your lordships, your ladyship, is that when you retire, could you kindly borrow something that I know you already know, that Article 138(3)(c) of the Constitution is the ultimate protection that Kenyans have been given with respect to the presidential vote in a presidential election. And if you do so, then I'm sure you will come to the conclusion that Article 138(3)(c) is a peremptory norm of the Constitution. It is a jus cogens norm of the Constitution from which no person is allowed to derogate. Not the IEBC, not the chairman, not the President of the Republic of Kenya, and by no means, not even the Supreme Court of the Republic of Kenya. That this court must enforce the fact that this is the highest Grundnorm with respect to the protection of Article 38 and by extension, the sovereignty of the people of Kenya. I will yield my remaining minutes to my colleague, Murara Moke. Thank you.
Good afternoon, Madam CJ and Honorable Justice of the Supreme Court. It's a great opportunity to appear before you once again this year. In quick rejoinder to some of the issues that were raised by the respondents, I'd like to urge the Supreme Court, when you retire to make your determination, to consider the historical context under which we operate, under which you make your decisions. The historical context is very simple, that in the last 30 years, you cannot identify a lot of instances of free and fair elections, except in the year 2002. And that one is there in history, that this is the only election that we've ever had in 2002 when there were no contestations between the winning and the losing side. But any other election outside of that, we've always had complaints coming out of those elections. And I wish to take this opportunity to urge you to use this opportunity to bring to an end what is becoming now a perennial problem to our nation, where we cannot talk about a free and fair election. It is very simple. When you look at this particular election, it's very surprising that anyone can tell you that there was no problem, unless they live in the Republic of Utopia. Anybody, even the children, our children, can tell you that there was a problem because they would see that the results were not coming out. We were waiting for the outcome for a long time. And in the end, whatever was announced left many questions. And this brings me to the test that should apply when you make your determination. The proper test to apply is the constitutional test when you sit to determine this petition. If you find any form of constitutional infraction, then you must nullify this election. There have been multiple infractions, very serious. And the question that must linger in the minds of the judges is whether you can trust the outcome of an election that is conducted by what I could simply call the Tower of Babel, because the IEBC, when you have two factions of an independent commission, that is something so serious. It should concern not just the judges. I was happy when I heard, Madam CJ, you said that you are very concerned by that. And I pray that you continue being concerned by that as you retire to make your determination, and that all of us in this country be concerned by that. That we had a commission that has two factions, that is run by what has been described as an executive chairmanship. I was very shocked. I could not believe what I was hearing today. And this was being said by counsel, instructed by that chairperson to come and tell you that he is an executive chairman. You should not accept that kind of description. It's not provided anywhere in the Constitution. You read Article 88, which establishes the IEBC. It establishes a commission, not a chairmanship. Article 249 of the Constitution, it establishes independent commissions, and it requires that these commissioners act independently, and they should not be under the direction of or authority of anyone, including the chairperson of any particular commission. The 7 commissioners, each of them independent, they are not to be held hostage, as they have been held hostage by the chairperson, who says he's an executive chair, and who not only says that, but also instructs his advocates to declare him a national hero. I think that is ridiculous. In my opinion, if there is any heroics that we should be applauding, all of us, is the 4 commissioners who are courageous for their courage, that they came out and said there is a problem. Because in this country, we must learn to speak up, we must speak out when we see a problem. And on my level, as an individual, I applaud them. And I think that what we should be applauding, we should not be praising things that are seen as unconstitutional. Very quickly, I would like to highlight other provisions of the Constitution that I think that should be looked at very keenly, and there was no compliance with that, which should lead the court to determine that there was no free and fair election. Article 10, was it fair and transparent? We cannot say that, because if we have a result that has been tallied and verified by a few commissioners, that the majority of the commissioners are not given the opportunity, or we have some results that were not verified, then how can we say that that's a fair and transparent election? I ask you to look at Article 81, the general principles for the electoral system, which talk about a free and fair election that is run in an efficient manner, that are free from any corruption. But we've had many shocking things, that in our country, we can have foreigners, even from the failing states, taking advantage of us, our systems, our people, and our electoral system. And the court should rebuke that kind of a thing. We should not allow it to happen again. It's a shame that Indeed, this is making us a laughing stock in the world. Everyone is laughing at us that we cannot carry on our own processes, simple process of tallying results and declaring them. That there's always a problem. When we could see the IEBC spending more time entertaining us with their music, instead of announcing the results, it was very irritating, I must say, as a voter, when you cannot find the results from the commission, but you find music that you could play very freely on your own devices if you wanted to. Article 138(3)(c) is very clear. It has stated that the role of verifying, tallying, verifying, and announcing the results is vested in the commission. 138(10), by referring to the chairman as the one who is declaring the results, is simply delegating that responsibility to him. And even if the chairman was not there, that function would still be carried out. If you look at the IEBC Act of 2011, Section 7A and B, it clearly provides what should happen in case there's a vacancy in the office of the chairperson of the IEBC. Things will go on. Nothing will stop, as the chairman would like us to believe. Everything will be carried on, even if the chairman was not there. And should this court find it appropriate to declare that there's an element of breach of Chapter 6, the court should go ahead and make that determination, and other processes can follow. As I close my presentation, because I have 1 minute, I would also like the court to consider very carefully whether we indeed have the threshold to declare a candidate as having won this election. As we speak now, we cannot determine whether we are not sure about the total valid votes that were cast in this election. And without that, you cannot determine whether we have a 50+1 threshold. And I ask the court to look very carefully. In my opinion, we do not have that. There's a lack of clarity. Mahat's presented figures, which I would say many of them were based on presumptions and projections. And that's not what the IEBC should be doing, not giving us projections. That is for the analysts to do. Independent analysts can give us projections, but for the IEBC, they must give us specific figures. They cannot give us figures that are merely projections or made up based on presumption. The figures of how many voters were astray, how many ballots were astray, should be verifiable. I urge you, my ladies, and when you sit to deliberate, let's make things right for our country.
Madam Chief Justice, kindly permit me to seek your guidance. I also appear in the same matter. There were some two specific questions that were put to me by Justice Lenaora and Lady Justice Jokindungu. I will only take 3 minutes and attempt to answer them. Madam Chief Justice, the question was put to me to try and link my arguments with the issue that we are canvassing here in respect to the number of the constituencies that must participate in a presidential election. To attempt to answer that question, Madam Chief Justice, permit me to refer the court to Article 136 of the Constitution, which provides that the president shall be elected by registered voters in a national election conducted in accordance with this Constitution and any other act. That election, the directive of how that election is to be conducted, my lady, is found under Article 138, Clause 2, which provides that if 2 or more candidates for presidents are nominated, an election shall be held in each and every constituency. And therefore the question is, the use of the word or deliberate use of the word constituency is deliberately used by the Constitution, and these constituencies are determinable. And if you want to determine these constituencies, you therefore go to Article 89 of the Constitution. You also further go to Section 2 of the Election Act and see what defines this particular constituency. Why is it important for us to factor this in? It's because any voting that was done outside the Republic of Kenya that is not contemplated by Article 5, which defines the territory of Kenya, then any vote that was cast is an illegal vote, is an invalid vote. and it is a vote that goes towards contaminating the election. Further, my ladies, my lords, in answering the same question, the constituency that was defined by the chairman makes us to have 291 constituencies, completely out of the realm of the Constitution. And that is the illegal infractions we are saying that the election has been infiltrated with. My ladies, my lords, when you are applying these arguments, or considering my argument, consider that you held in Raila 2 that under Section 83 of the Constitution, if any of the issue, either be it legal or factual, is proved and ascertained, then that issue can void an election. The question of the constitutionality of that one extra constituency is an issue that contaminated this election, and it's an issue that should be factored and should not be lost in the eyes of this court. Finally, allow me to sum up by saying that Thomas Paine quoted and said, "A body of men holding themselves unaccountable to nobody ought not to be trusted by anyone." If IEBC does not hold itself accountable to anyone, then who should trust them? Can we even trust the processes under which they have taken through this country? I bet not. I beg to rest. Much obliged.
Next is counsel for the sixth petitioner, Mutembei and others. 15 minutes.
May it please you, Madam Chief Justice, Madam Deputy Chief Justice, and members, honorable members of the Supreme Court, I wish to respond in 15 minutes, which I shall share with Mr. Mutembei to break down the figures to show that the threshold under sub-article 4 of 138 was not satisfied because the numbers simply don't add up. But I will make a few remarks, Your Ladyship, because there are a few questions that I needed to respond to as well. It is now clear that the ipse dixit of the petitioners on the question of compliance and non-compliance of the Constitution is now sound. And clearly Articles 81 and 86 are in question on compliance. The respondents, my lords, have put up, the second respondents have put up a self-righteous and pompous response on the question of the role of the chairman. And I want to just respond in this manner, my lords. Section 5 of the IEBC Act defines what a commission is. And a commission is defined to include the chairman of the IEBC and the members. That definition, my lords, contrary to the submissions by Mr. Karori, senior counsel, does not include and expressly excludes the staff of the commission. It cannot therefore lie in the mouth of counsel to submit that the verification and the tallying of the results of the presidential elections, insofar as Form 34As and 34Bs were concerned, was done by the staff and excluded the commission, who were confined to other duties. My lord, that was a violation and an infraction that expressly went against the requirements of Article 138, 3C. Secondly, my lords, the submissions by learned friend, senior counsel, Professor Githu Muigai, on the executive status of the chairman of the IEBC, I think should be taken with a pinch of salt, because Article 249(1) of the Constitution does not contemplate an imperial chairman who is all-fearing with fear, favor, fervor, and fiat. That is not the chairman that we have. The chairman of the IEBC, appointed under Article 250 sub-article 4 of the Constitution must be that chairman who is the first amongst equals, just like the Chief Justice of the Supreme Court. A primus inter pares who must work with his colleagues to guide the affairs of the Commission. I urge the Court, therefore, to decline an invitation by Professor Githu Muigai that the chairman of the IEBC is in a special position, different from the 4 commissioners who are crying aloud to be heard by this court. And my lords, this petition number 5, as consolidated, therefore tilts on the violation of Article 138(3)(c). It tilts on that violation. And that violation alone, my lord, therefore invites this court to look at or to turn to Articles 23 of the Constitution on your role as a court to interpret the Constitution in a manner that goes beyond just protecting human rights, my lords, but to look at what would guide your interpretation, the holistic approach, the purposive approach, and let me borrow my learned friend's approach, the Antonin Scalia's approach, the late judge of the US Supreme Court, the textual and the contextual approach. And if you apply those approaches, my lord, then you will find that the chairman of the IEBC, in failing to properly construe his role under 138(3)(c) and 138(4), violated the Constitution, and an unconstitutional process therefore emerged that cannot put into place, my lord, a process that violates Article 3(2). My lords, there is an invitation to you to invalidate the entire process. And that is why, in answering in answering the Supreme Court judge's question that was directed at me on remedies, I wish to state that, and this is because this court also has a purpose under Section 3 of the Supreme Court Act. And given that you're an election court under 84, in an ideal situation where you are construing Section 83 of the Elections Act, which must be interpreted disjunctively, because if there's an unconstitutional act, then the election cannot stand. If quantitatively, as we shall demonstrate, there is non-compliance, again, you'll have to invalidate the election. But my lord, in an ideal situation where you'd have been called upon to apply Article 232 on public service and Article 201 on public finance, you would have ordered a recount and then secured a winner. But this would only have been possible if there were no unconstitutional infractions that undermine the process and therefore make it unconstitutional. Because this is no longer about tallying and verification. It is about the bigger process of the involvement of commissioners and a split commission. And the only remedy available, my lords, Justice Ouko, the Chief Justice and member of the court, is a nullification. This is no longer the baby of Raila Amolo Odinga V. This is no longer the baby of William Samoei Ruto, Doctor, the first respondent. This is the baby of Wanjiku. It is the baby of Kenyans. Return this baby to Kenyans to determine to whom they shall hand over the baby after 60 days. I pray that you nullify the election. And I will cede my time now to Mr. Senator of Busia County, Okia Omtata, the perennial litigant. Thank you.
Distinguished honorable members of this court, I'll begin my submissions by requesting that my PowerPoint presentation be played.
Just to respond on points of law.
My lady, there was a question that was posed by Justice Ouko.
Yes.
Which Mr. Mohammed answered.
Okay.
And I would like to make a clarification on that. On the points of law, I think Professor has covered.
Okay. So you're only answering the question by the court?
Yes, my lady. Could the time be stopped, please, so that... Yes, we are going to interrogate the figures that were used here to attempt to mislead this court. I'll begin by asking the officer to play the slide number 6. That slide that contains results, when I looked at it, and my other co-petitioners, we found that the maths did not add up. And that for us was a smoking gun, because figures don't lie. So, and I would also ask the court to realize that the comments we made about that particular result have not been challenged. That when you add the totals for the individual parties, you don't get the total ascribed. But the total ascribed is available in the workings and the affidavits of the members of the commission, which means we are dealing with fiction. I would request that you go to slide number 5. And the Honorable Judge asked, how are these things transmitting? So when you look at the fact that at 17 hours, we had 21,481,652 voters or returns which had been made, and we factor into when we try to calculate the average number per voting station, we were told we are given 46,299 polling stations. If you divide 22,120,458 by 46,299, you arrive at an average figure of 478, which is not very far from when you take 65% of 700, which is the maximum number you can have in a polling station, you end up with 455. So when you now come and using the 478, which is the average we have had, and divide 21,481,652, you get 44,962. From paragraph 29 of Mr. Chebukati'S replying affidavit, the figure he gives is that 45,994 kids reported. Now, from this, you already see that if the kids were 46,299 and 45,994 had reported, you are only left with 305 kids. These are kids which had connected, so the question of saying that these kids were looking for connection is not there. These kids were connected and they discharged their mandate. And you have been told here that there were some kids in Eldoret who are pinging the same, we are sending results from Eldoret, I don't know from wherever, when kids being used. So at that time, you get that the 305 kids, which may not have had network, if you multiply that figure by the maximum number of votes available, you will find that the 700, if you multiply that, you'll get a figure of about 213,500 votes. That's the maximum that could be transmitted, not 2 million votes. And also, if you went by my working of 1,337 kids, then the maximum amount you could get is 638,806. So the kids that transmitted are not these ones that reported at that time. But the data, the fact that they held so much data was mined. So somebody could transmit remotely mining the data that was already reported in these polling stations. And that's how the fraud happens. For the workings on slide number 2, where you can clearly see that if we use the 21,481,652 as the baseline and the 12,065,803 as the baseline, you find these workings coming out, and you can see that 1.6 million votes are being submitted between 17 hours and 2045, and on and on. But most important, even if we were to buy the idea that they were connecting, you have got 508,647 ballots on page 3, slide 3, which transmitted after a period of 3 hours and 45 minutes. So those particular transmissions of 508,647 are a figure that's very curious, because if you deduct the tally for Elders from this figure, you hit almost the exact figure that Mr. Willis, Land Council Willis, has presented to this court, coming from the KPMG audit, that there was that number of voters, there was a number of ghost voters equivalent to that one. When we go to the other thing that supports our position, there was a question of what was the denominator used for voter turnout. I will invite you to look at at the petition at page 41. There's a letter, a press statement signed by Mr. Chebukati, saying that he used the National Voter Register to calculate. And if I may just read it quickly to the court. So page 41 is handwritten 41. It says, paragraph 2, at around 4 p.m., 12,069,803 registered voters out of 12,065,803 voters out of 22,120,458 had cast their vote. This equates to 56.17% of voter turnout.
How much do you need? Because we have that slide. Could we give you 2 minutes to finish?
Here that you will refer to the slides. So, when I look at that, you will find that there's no basis for claiming that the figure that claiming that the Kim's kids were used as the denominator. It's not possible, and it's not there. Also, I would like this court to take note of how the percentages are being played with. That's slide number 10. You will find that whereas the chairman is reported 12,065,803 people voted, who voted represented 56.17 of the total registered voters of 22 that. At paragraph 26 of the replying affidavit, Mr. Sunkuli, using the same number of voters, 12,065,803, but as reported by the chairman, but again as a different number as a denominator, he arrives at the same percentage. So there you can see how they can play with numbers by changing the denominators and arriving at magical figures. So my members of the Honorable Court, my prayer is that my submissions are that these figures are cooked, they were worked backwards to achieve a certain figure, but fortunately, on the Form 34C, the smoking gun is seen. And since figures don't lie, and if the math doesn't add up, then this court should quash the results. We were told about military precision. Military precision is the ability to shoot a bullet with a bullet. That's how a missile downs another missile. That is not what we are saying here. There's no military precision in these figures.
The last petitioner, seventh petitioner, Julia Nyoka Bichege, and others.
May it please you, Melody, Madam CJ, and other members of the court, to go straight to the issue. I've had a lot of Shakespeare and other learned fellas. I went to public schools. I may not be able to remember anything about Shakespeare. But Madam CJ, besides a Greek philosopher known as Plotinus and Adam Smith, my favorite philosopher is called Karl Marx. And one of the most famous quotes that he made is this, that history repeats itself, first as tragedy, second as farce. Now, I go to my issue. Yesterday, Madam CJ, when I was listening to my learned colleague, Mr. George Oraro, Senior Counsel, I could not fail seeing the echoes of 2007 in what is happening today. Madam CJ, in 2007, the secretary to the commission, just like this year, was at the heart of what happened. The secretary was called Suleiman Dongo. Suleiman Chege. The secretary today is called Hussein Marjani. Same problem of numbers. The Kenya law reports would bear, and Mr. Isa Mansour is also here, that I represented Samuel Kivuitu and others when they were removed from office. Now, it turns out that, and listening to my learned colleagues, that just like in 2007, the person who knew why the results are like that was Suleiman Dongo, Suleiman Chege. Listening to the presentation yesterday, it also appears that the only person who really can tell us about these numbers is Hussein Marjani. Second similarity is that both Raila, Odinga, and William Ruto were at the heart of what happened in the year 2007. But that is not the more important point. The more important point is the differences. The differences were these. In 2007, and under the constitution that was existing that time, the election was announced on the 30th of December, 07. And the president sworn on that day assumed office. But the difference this year is this. After 15th courtesy of the new constitutions, on the 15th of August when the declaration was made, the person designated as the winner by Chebukati became president-elect. That's an important distinction. The second most important distinction is this, that the former constitution of Kenya did not have an equivalent of 138 of the constitution. There is that distinction today, which is what I was calling stage 3 of a presidential election. It was never there. The next issue was that in 2007, the presidential elections were held by the High Court under its original jurisdiction and special jurisdictions of elections. This one comes to the Supreme Court, and the basis upon which that is done is on the basis of Article 140 of the Constitution. There is no sitting president who will be appearing before you. There is only a president-elect. Now, my first petitioner, Julia Shege, asked me, because there was a subjective question that was posed in her view by Judge Smoky Nwanjala, that how come there was no protestations by these people when they were being given domestic chores? According to Julia Chege, who had to resign from her university job as a lecturer, there is something that needs to be understood, that for 99% of the human population, you want to follow the natural order of things. You don't disturb things. You let them things as they are. So that to Julia Chege, it is important that the court must understand that from your point of view, a lot of you, and she knows that history, have had a previous opportunity to stand up for something, an opportunity to say no. Not everybody has had that opportunity. And therefore, the 4 commissioners for ultimately, on the 15th, having the courage to have something to stand for. They are heroines and heroes of this country. We come now talking about heroes to what my professor of criminal law and procedure, Dr. Gethu Muigai, said. Dr. Muigai, looking straight to the face of this court, said 2 things. A, the problems in our elections is not IEBC, but the candidates. History does not support that conclusion. Second thing he said, B, Wafula Chebukati is a national hero. I don't have to say anything on that. Now, Madam CJ, there is the issue of the word independent, or in the designation of IEBC. The word independent, it is further elaborated by under Section 26 of the IEBC Act. It says IEBC is independent, but shall be subject to public participation and to engage stakeholders in the discharge of its mandate. Madam CJ and members of this court, I flatter myself quite often that I have a reasonable understanding of Kenya's electoral laws. However, Madam CJ, listening to my learned colleagues yesterday, I had a lot of reasons to doubt whether that is true if what they said is actually the true representation of the law. And in several senses, under Article 81, the election should be simple, accountable, accurate. But until yesterday, my understanding was this, that reference to the Commission and Article 81, 86, 88, and 138 of the Constitution triggers the image of Chebukati and 6 others. I've never imagined Marjani and other returning officers when we talk about the Commission. B, based on sections 10 and 11 of the IEBC Act, my understanding has always been that the Secretary of IEBC is the chief executive, the head of the secretariat, the main employee of the commissioners, who appoints him. But now it appears to be that for purposes of a presidential election, and we heard it from his lawyers, he's actually the main man. Was this what the Constitution wanted it to be? Welcome to the Republic of Kusadikika. I must agree with my learned colleague, Mr. Muthomi Diankolu, that it would appear that since we did our elections, we became some kind of a terrestrial Kusadikika, and several questions arise. When, why, and how? When did this happen? It first happened just before midnight or 9th of August, when we retired to bed. One figure we ought to have had was not known. How many of us voted? That is the when. How did it happen? It happened because on the 8th of August 2022, Wafula Chebukati published that Gazette notice that I talked about. On the face of it, makes the chairman a dictator. No, that is not the issue. If you read it as an instruction manual, it was to give the job to Hussein Marjani. That is what happened. Why did it happen? It happened, and we explained in our affidavits, paragraphs 42 to 45, and what they say that effectively, on the 15th of August, when these elections were declared, from 7:30 to 6 p.m., on that day, the commission, as the commission, had lost effective control under Article 138 of the Constitution. I come, because I'm trying to rush myself, to the petition, number 7. This petition, Madam CJ, is actually a numbers petition. I didn't want to make a lot of fuss that I would have needed more time, but in case my mouth does not go fast enough, I urge you that you give me a little leeway to conclude what I need to say. The issue is this, Madam CJ. When you pose the question that you posed, how do you have evidence 700,000 people did not vote? You triggered some kind of public participation on my phone. I had many calls. Kipe, why did you just say it's 700? It's about 3 million. But of course I had to tell them, no, we just said 700 because we had some kind of evidence. So it's a big issue, Madam CJ, that you triggered a public participation. So many people don't vote on account of non-enforcement of Regulation 90 by IEBC. Now, for whatever the value is this. I can demonstrate very shortly, and we've done that in our petition and in our, in our affidavit, that when you have a petition based on non-compliance, how do you prove it? We have an affidavit of Julia Chege that basically has not been controverted. She says where she was voting. She was voting as an MP she was contesting the office of Kangema. And she said how she interacted with election officials. There were no affidavits sworn by the commissions to say those interactions she talked about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, IEBC needed to do a very simple thing. Namely, what did you publish to implement it? If you didn't publish anything to implement it, you are responsible for non-compliance. How do you treat non-compliance? You tell the Supreme Court. We could not be able to have non-compliance for reason A, B, C, D. Then the Supreme Court may decide to excuse you or not. But in the absence of that, non-compliance has been proven. What is the effect of this non-compliance? We have stated in our further affidavit, it's a numbers thing. If 700,000 people did not vote and you adjust it whichever way you want, you will still have a figure of 300,000. So that the long and short of it, my ladies and my lords, is this. Unless you excuse IEBC, and they did not ask you to excuse them, then you must find that the numbers in petition number 7 could have altered if those people had voted the results of the general election. And therefore, it is not permissible for anybody to be able to say, oh, it's a numbers thing. Petitioners brought no number. We brought numbers, and there was no response. We come to the issues of the issues of the procedure under Article 138. Under Article 138, that's one of the best done judgments that I've read. I've read it many times. It was written by artist Judge Jouko was there writing it. Catherine Mantoinoti was there. He was my pupil master. One of the best written judgments. I've read it many times. But yesterday, it somehow appeared, I don't understand these things. So I read one more time yesterday night. And I thought, I think I understand what it says. So it was violated in 3 major ways, my lady. Number 1 is this, issues of the voter turnout. The issues of the voter turnout until yesterday, I thought is usually settled before the elections through the gazettement of a voters register. For these elections, it was done on the 21st of June 2022 through Gazette number 7290. But listening to my learned colleague, Mr. Somane, it would appear that fairly educated people like James Orengo, Firoz Noroji, Paul Mwangi can actually write petitions, and they were told in open court, they did not understand what is all this about Article 190. And I also shuddered that if they didn't understand, probably I also did not. The second failure is this. In short, I'm saying the register cannot be mysterious. If the register is mysterious, the election is not simple, does not meet the requirement of Articles 81 and 86. Number two, the stoppage of the public display. I didn't hear a straight answer to that. Now that there was no straight answer to the issues of the failure of results, and the 27 were not read, that goes straight to the root of the procedure under 138. If that was not done, my lords, there is no way in which you can be able to say the election was valid. For a simple reason, which is this. When, can I have 2 minutes? 2 minutes. Yes, I can give you 2 minutes. For the simple reason that we were dealing with under Article, the conclusion, the whole point about Article 138 is that the procedure must be concluded. If it is disrupted, you have to hold that Article 138 was violated. The next issue is this, the third one. We talked about the issue of effective control. If you are convinced by what you have heard, and we have gone through this in the last 2-3 days, that IEBC lost effective control from 7:30 on the 15th to 6 p.m. when the results were read, there can be no basis for this court to say anyone was validly elected as President of Kenya. My learned colleague, Mr. Fred Ngatia, whom I respect a lot, said that William Ruto won these elections fair and square. That expression, fair and square, to my mind, comes from, as I understood, the famous judgment where Judge Madan was in the Githunguri case, where the basic point was this, that certain issues may happen that may make even a person who on the face of it could have been liable for criminal offenses not to be properly tried. And therefore they said it makes any conviction to be bad in law. You do not have a fair and square deal. Under Article 138, Raila Odinga, the other surrogate petitioners, they need a fair and square deal that their votes were not enough. Finally, my lady, the Chief Justice, Article 138 must not die in your hands. We are most obliged.
I think that brings us to the end of Yes, that brings us to the end of rejoinders. We are looking at Senior Counsel, Mr. Mwite, but we know very well your clients were respondents. It was only for the under representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Chief Justice, I am acutely aware of the time constraints within which this honorable court must adjudicate on this petition. And may I say that this honorable court is entitled, suo motu, to decide that the 14 days specified in Article 140 mean 14 working days. Yes, to exclude Saturday, Sunday, and public holidays. You can do that, you mortal. I am pleading, Chief Justice, I'm pleading on behalf of the 4 commissioners. I plead. They have had very, very little time in this court. I plead.
Well, that is why I was looking at you with the questioning eye, because there were some questions also which were asked, and they need to be responded to.
Yes, those are the ones. I'm just pleading.
Yes.
Allow my colleague Mansu Issa some 8 minutes, and Dr. Arroa some 3 minutes, and yours truly some 2 minutes only.
That is 15 minutes.
Because, yes, because...
To answer those questions.
Because, Chief Justice.
Yes.
Those questions directed at those 4 commissioners are very important. And
Thank
when
you.
others were answering questions, a lot of maligning, a lot of... Please give them that opportunity to have their case stated. They are the majority in that commission.
Thank you, Senior Counsel. I think we've heard your plea because we asked questions. So we'll give them 15 minutes to answer, not now. We want to take a break. And immediately we finish, there was an issue raised by Senior Counsel Gatia responding to some 2 Forms 34, and you asked for 5 minutes. And then we will give the parties 15 minutes, not all the parties, the ones who are connected with the discovery and the scrutiny, 15 minutes in the afternoon to respond to the report.
I request, Madam Chief Justice, may I request 5 minutes for the Commission, because we are the custodians of the form, the legitimate forms.
Yes.
And my learned friend, Mr. Orengo, needs his lunch now. He's heckling.
Okay, we'll give you 5 minutes, and the court will arise.
To know whether he was gazetted as an agent of the Commission or he was gazetted as national returning officer in his capacity as the chairman of the Commission, and whether, if it was as an agent of the Commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters who were identified through Koom's kit, and this is out of 46,229. Sorry, that Koom's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Koom's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Raro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the qualitative, the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it? And what is the approach you should take in this case regarding the test to apply? Number two, again to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did he not wait until that day? Violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyo and Mr. Kihara and the rest are coming from. We are now in a sport where public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination? What do we do with the matters you placed before us? And while you're at it, you also mentioned Section 83. Perhaps you could also say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus, but as a respondent.
For the 18 polling stations, the report of the registrar, it exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations. Even if you looked at the scrutiny report, that gives you a figure of 90 in the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that you know, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and if that could run, the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballot. So to the question that someone can vote for one candidate and leave the others, it's not true. It's actually, the regulations don't allow. It's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence, 229. I think the number you are interested is how many people voted manually, 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kits, right? The second question, Justice Ouko said, Omtata says 1,665,412 people curiously voted for when the polls closed. And I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it. It sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah. So that is how the number changes. The polling will close, but some kits will be sending the people, how many people went through. And it's only when we know when all the KIMs have transmitted and we know how many people have voted manually that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commenced on 6 a.m. on the next day. Some places in Eldas, KIMs reported happens once the network, once it has network, and it requests to connect. So I think it's a false analysis because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMs will keep on giving that information. Justice Lenora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training Form 34A. I have also given the password. The court can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper. It will ask you for the gray scaling, and you will see how we do it. And we do for JPEG because all your phones take JPEG. We want to differentiate our image from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start from. The reason why we give turnout is a measure of transparency and integrity to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the KIMS 589,961. On 10th August is 21,926,565. If you deduct those numbers and you compare to the people who are actually identified by the kits, actually, the people who are identified by the kits is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So, 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reached 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified as the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMS have reported. So when all the KIMS had reported, because this is a snapshot of that information in time, when all the KIMS had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that policy we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deploying of infrastructure and the servers platform. They did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact, the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there's no agent, Justice Mulo asked, if there's no agent, what happens? The integrity, the processes that we have in terms of the KIMS return, in terms of the portal, even if there's no agent, we can actually confirm what happened. So it's not the role of even if someone said I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have, go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that. If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the IEBC logo in the background, both images same. If you look at the exact paper fold in the bottom left corner of both images, same. The image is brightened to show that it has undergone editing. That's the top left is dark. The agent copy is in JPEG. The form is uploaded on the, our form is uploaded on the portal 10th of August 2022 at 2 days. Actually, you can check all the edits.
Sorry, Council, you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave two examples. If you can just go back, I think I'll start with the first one. The 185, yeah. If you can go back.
We'll give you 5 minutes, see what you can do with it.
Yes, yeah. Thank you so much, Madam Sinje. So what we did is we just took the form they provided us and we juxtaposed as against what we have. And we've marked all the places what is wrong with that form. And what is wrong with that form? If you look at the QR code, up on the left, on the right, and also on the left, the QR code, it's cropped similarly in both pictures. The IEBC logo underneath the document coincides with what was the pressing officer. It's actually an impossibility. I've given you a form to take a picture, and what you are producing me is actually underneath the logo of the document, the IEBC logo that the presiding officer was using. So I've given you your form, you're taking your picture for your agent, and you're using the same that the IEBC PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact, you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's no any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong, the exact same fold. It's an impossibility. I mean, you have 41 polling stations all over the country, and the form they are giving is at the same elevation as what we have given. The picture that our PO took on the background of the Kim's kit is the same. And you can tell, and the reason why we were saying that it's an impossibility is because there's nothing else you can change from those forms. You cannot change the signature of the agents. It's an impossibility. The only thing you can change is the tallying. You can try changing to JPEG and try to amend the tallying. And that is really important. That is the crux of this matter, and the court has to look at that and actually make a finding. I will try to also, to Justice Ouko's question about the stray ballots. I just want to mention that the court report bears out the assertion of the IEBC. If you look at the report that was done relating to the stray ballots, I went through the court report and actually tallied the stray ballots. It is 2 per polling station. If you project this to the whole country, there will almost 90,000 stray ballots. And the way you account for stray ballots is they are put in the polling day diary, PSD. I have provided the polling day diary for 2 of the constituencies to just give the court comfort that as IEBC we can account for each and every ballot. To the question that has been asked by Justice Wanjala on the turnout, a clarification was given, and this is the assertion of the petitioners. They are saying, we are not interested in the clarification given by the chairman. We are going to take that turnout of 65.4 as against the total registered voters, okay? Then come to the conclusion that there are votes that are unaccounted for. And we are telling him that is not how we do it, okay? Turnouts, we give the number of people who either have passed through that kit on at a snapshot, okay? And there's nothing much about it. The declaration is made on the actual physical ballots that we count. We count the physical ballots. After counting the physical ballots, we tally it. Madam DCJ asked about the rejected ballots, whether they are different from the rejected. So the way we calculate turnout refers to the number of people who have passed through that polling station in the 46,229 polling station in the Republic. We have not even reached the issue of rejected ballots or anything. It's how many people appeared that day. So we have a number. Then we do the counting. After counting, we get rejected ballots. So how do we determine 50 plus 1? We will say, okay, what are the total votes cast? And we will refer to the 2013 and 2017 decision of this court that said rejected ballots are not a choice of preference and the same have to be removed. So the idea that turnout is affected by rejected ballots or doesn't matter, it's just a measure of transparency. And you have to understand how the reporting of the KIMS happens for you to be able to do. We only give what we can at the time, and we'll keep on doing that. With those
Thank you, Councillor. You're not even being heard. But thank you for answering our questions. On the kit, please deal with the registrar of the court. Thank you for your assistance. Your time is up.
My lady, I do not know whether you can give me 2 minutes to respond to Lady Justice Jokindung.
You're not helping me to do my day's work very nicely.
I'm sorry.
But 2 minutes would mean 2 minutes.
Yes, please.
So that you don't go away saying you are not heard.
Thank you very much, Deputy Chief Justice. The Honorable Justice Jokindung wanted to know from me of my personal experience as a draftsman of the original Constitution, what our intentions were when we created independent commissions. And my simple, straightforward answer is, we were trying to create greater autonomy and functional independence. You will recall elections, for example, were under the Attorney General's office and were under the hands of a person called the Supervisor of Elections. And that had been not very successful. What did we achieve? The one thing we achieved is that we created independent commissions that do not function in the same way. For example, this commission, the Electoral Commission, the chairman has executive authority because this is one of the very few commissions where the commissioners themselves do some actual work. This is very different from EACC. EACC, the chairmanship is not executive, and the commissioners do not do executive work. They cannot determine to charge anybody or to investigate anybody. That is a work done by management. Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, Melody, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many, many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
We thank you, the Honorable, the AG Senior Counsel. Thank you very much. At this juncture, I return this to the Judge President to lead the proceedings.
Yes. Yes, thank you for that session. We are really mindful of the time today because we wanted to finish these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Rengo,
the Chief Justice, before the main petitioners commence their response,
yes,
there were issues.
Volt helps you move around, but when you move, you generate emissions. To neutralize them, we're planting 11 million seed bolts. There are seeds covered in recycled charcoal to protect them from birds, insects, and rodents. They'll grow into trees like kirky, polyacantha. And with 11 million seed bolts turning into trees, we'll neutralize
Madam Chief Justice, you recall yesterday how gracious I was. I donated 32 minutes to court.
Are you claiming it back?
No. No, I will not do that because the court has work to do. All that I request is 5 minutes, nothing more than 5 minutes of your time. We are doing quite well this morning. Thank you so much. I don't know who will go first, whether it's my senior or ourselves.
I think you can go.
Chief Justice and Deputy Chief Justice, members of the Supreme Court, just to point out that there were specific questions that were addressed. For example, to counsel acting for the 4 commissioners. And we would like to know at what point we are expected to respond to those questions. After the petitioners. Thank you.
Good morning, Madam Chief Justice and members of the court. I seek a little clarification because similarly we had several questions directed to us which we thought we would react to before we make our rejoinder. And I thought yesterday you had clearly stated that we'd have 30 minutes. We had about 27 questions. Are we at liberty to proceed to answer those questions right away?
Sorry, Senior Counsel Lengo, you have 1 hour to respond, but I hear you saying you need more than 1 hour because of answering the questions. And therefore you're asking for another 30 minutes.
With a little bonus.
We can see what we can do with 1 hour. If you extend maybe 15 minutes.
It would not be enough. There's a very important question which just...
It's all right, because even the time we are wasting now, you could be answering.
Yeah, so
Yes.
in the 30
Just
minutes...
asking you to be kind, because we really have to get to the real business of writing the judgment.
Thank you.
And we don't have much time.
In the 30 minutes that we'll be answering those questions,
yes.
My lady and my lords, you'll be addressed by my honourable friend, Mr. Otiende Amolo, particularly on the question of turnout, which was asked by Justice Wanjala, and Firoz Norji, Senior Counsel, Paul Mwangi, and Ms. Julie Soweto will address you in those 30 minutes. And I invite Senior Counsel Otiende Amolo to address you on the first question.
Yes.
Not yet.
Not yet. Not yet. Yes. Senior Counsel Oraro, please, or is it Gatia?
My senior is beckoning my team. You allow?
Yes. 5 minutes.
Chief Justice, Deputy Chief Justice, distinguished judges of the Supreme Court. Actually 3 questions were asked that are relevant to our submissions yesterday, paraphrased as follows. 1, if the National Security Advisory Council 4 knew the results before they went there, and 2, why would the result not be announced the next day to build consensus, and 4, what would be the effect of the non-involvement of the 4 commissioners in the verification and tallying vis-a-vis Article 138(3)(c. Our response is as follows. 1, it is our submission that all factors point to an inescapable conclusion that the 4 members of the National Security Advisory Council, by the time they went to the Bomas of Kenya National Tallying Center, and by the time the head of public service placed a call on the returning officer of the presidential election, by that time they knew. And this is our evidence. By the morning of the 15th, letters had been issued by the returning officer of the presidential election, Mr. Chebukati, to all the presidential candidates and members of their family to be at the National Tallying Center for the declaration of results at 3 p.m. on that day. And my client already had received that invitation. I believe the other presidential candidates had those letters. And therefore, they knew by the time these state officers went to the National Tallying Center, they knew that the verification tallying had been completed, and what was pending was the declaration of the final result. It is our submission, Chief Justice, distinguished judges of the Supreme Court, that these 4 went to the National Tallying Center not for any other reason, but to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya, which had already been verified and tallied in accordance with Article 138(3)(c). 2, it is our response that the results could not be announced the following day because, according to the affidavit of the chairperson of the commission, and I'm using the word chairperson on advice by Justice Ndungu, which I agree with entirely, that by that time, it was not possible for any form of consensus, because then the follow-up question was, I think from Justice Lenaola, why, for example, the returning officer would not have waited for an extra day, which he had, to build consensus on the 4 walk-away commissioners. It was not possible. It was very clear that the intention was to try and veto the will of the people, and therefore the chairman had to declare those results. Number 3, the 4 who left also, their colleagues had been injured. And so the chairman had, in our view, make the announcement that day because of the gravity of the situation. Finally, the question that this court ought to ask itself is whether the working away of 4 commissioners at the tail end of a process which they have admitted was complete, except the declaration, can veto the sovereign will of the people of Kenya. Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter? Thank you, and we prayerfully submit.
Chief Justice, my lords, Deputy Chief Justice, Lady Chief Justice, I'll begin with the question which was asked by Justice Lenaola, and that is, what orders are we seeking? The orders we are seeking is for this honorable court to dismiss the allegation by the second respondent on oath, which have not been accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act, and Article 183(3)(c, is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Wanjala, and you queried whether NSC would have gone to influence the alterations of results without knowing the results. My learned friend, who has just appeared, exhorts that the results were known because invitations had been sent out and the letter had been sent out. To the contrary, the evidence before you by the chairman was that he had gone to tally, to obtain the final tally only after he had met the commission, and that is found at paragraph 676 of his affidavit, where he says that after the NSAC team had left, the commission secretary, chief executive officer, who was also the alternate team leader of the tallying center, Marjan Hussein, walked into the boardroom. Yeah. The purpose of the meeting was to receive the final tally of the results of the presidential elections before he could proceed to declare. And it is only thereafter that the results were handed to the commissioners and they walked out. So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left. Now, the Deputy Chief Justice asked about the effect of NSAC on the independence of IEBC. Your Ladyship, NSAC is a body comprised of all the heads of the security organs in this country, the head of civil service, the representative of Attorney General, and other heads in the government. Its purpose is to receive all the information on National Act, but give advice, so that even if they are of the view that it is insecure to be in this court at this time, it is the NSC who will give advisors of the NSAC who are co-opted by the bigger body. They were not there on their own account, which has led to them now being vilified for undertaking an official duty they were requested to undertake. I had shouts from another friend on behalf of His Excellency, the Deputy President, of crucify them. In fact, this has indeed led to tweets today, and there are many, to various members of the NSAC telling them we shall revisit. This is what this type of allegation brings, and that is why I humbly request this court to look at the nature of the allegation, the burden on the people who are making the allegation, and dismiss them if there is no proof, and in my humble submission, there is no proof, so that we discourage this political vilification on officers conducting their official duties. Let's be careful, and I humbly request, particularly my learned colleagues, on what we wish for this country. Let us not wish mob justice to be the arena of operations whenever various functionaries are discharging their duties. Let politicians do politics, but let them leave professionalism to those who are engaged in various areas. In fact, since this process started, there has been a lot of vilification on the judges, on the parties appearing. In fact, tweeting has been the norm on discussing this issue instead of looking at it soberly. We can't stop tweeting. They are entitled to, but we can't bring it to this court. That's my humble submission. I beg that these allegations be dismissed with the contempt they deserve. My learned friend, Mr. Ngatia, requests for donation of the 2 minutes to him, but I really would wish not to be so gratuitous.
Thank you. Madam Chief Justice, if you may allow me, I did not put one of our lawyers on record, Mr. Donald Kipkorir, who is not in court because of the sitting arrangements. But to come to the business before us, in answer to the questions, four of us will deal with all the questions that were asked by the court, beginning with my learned friend, Mr. Paul Mwangi.
Madam Chief Justice, Madam Lady Deputy Chief Justice, my lords, my ladies, I have 9 questions which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the counts of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have 6-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, and our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner, and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioner benefited from any of the wrongdoings that are complained of. And thirdly, that after whether it is a recount or a retally, the petitioner appears to have won the elections or has won the election. Those would be the tests that we would add to what is stated in Section 80. In respect of the question of image on the KIMS, the evidence that has been shown also even from the Commission is that the images are taken on a JPEG format, and the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, and nobody changes. We get a lot of images as original as they are, as colored as they are, in the hundreds on an everyday basis. And I do not think there is any justification why an image taken on a JPEG on a KIMS kit cannot appear in the same format throughout the electoral process. The other question was in respect of the evidence, whether the 4 commissioners participated and what that meant. I would ask the court to look at the annexures that are put as MWK3 in the affidavit of the second petitioner, Martha Karua. And in that flash disk, there are 2 incidences at the National Tallying Center. In one incident, Commissioner Justice Nyang'aya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniora Cherele. Again, she's given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the IEBC, is a person who has qualifications similar to be the Supreme Court judge. So it is him who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the 4 commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile 3 theories. One is the issue of the 89th minute penalty, that if you participate in a game and a wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at it, it is an issue that is understandable. The other question is in regarding for if there were to be ordered an repeat election, who would conduct it, would go back to Article 250, Sub-Article 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, in inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there's a jurisprudence that is being built that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the IEBC from any duties because there was no agent. And in fact, one of the advocates likened, said that you must have agents in every place, and even likened to agents. I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism. Their course must restate the duty of IEBC to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Maha did, I want to show the court a Form 34A from a place called Gasharaigo Primary School, and it is in Murang'a, in Kangema constituency, in a ward called Murogo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of IEBC. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Joseph Camargo. And we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.
Good morning, my ladies and my lords. I will pick up from where my learned colleague and senior Mr. Paul Mwangi has just left off. The court had asked that we demonstrate with examples in real time how the Form 34A was interfered with or could be interfered with. And I will do so showing you or using the IEBC's forms itself, straight from the IEBC, from the IEBC portal. My lords and my ladies, I will walk you back through the form that we have just showed you. I see that the court has laptops, which means you're tech savvy, and you can access the IEBC portal right now. This is going to be a live demonstration as the court asked that we do. I'm asking that we go to the forms portal in the IEBC. We are projecting it up. So that it's not said, because we have been accused of cooking things, forging things. We've been called many names. This is the IEBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County. Kangema, Muguru, and Gasharaigo, Primary School 02. This is live. My lords and my ladies, we have downloaded a Form 34A from the IEBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IEBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. The votes. Now, my lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Maure Waiga, 001. And the last is Wajakoya 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. It is obvious to the naked eye when you look at that form. Now, when we go to now the bombshell itself, the top left-hand corner of the form, we were told by my colleague, Mr. Gumbo, there were no foreigners in this election. We were told the foreigners left before the 8th of August. We were told they did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? What are you doing? This person is the one who was interfering with the forms. We are able to demonstrate, at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
you read our finish and then you tell us what it is. They're responding.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
My ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition, and is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IEBC live portal to show how the staging was happened. And because of time, if we can go to Bungoma. We want to do it live, and we're doing it live on the IEBC portal. My lady, we were told about the KIMS kit and how they work. the serialization of the numbers, we have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyiwa. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates. And then it will show you the KIMS kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Do you have a roving mic? Now, the serial number on this particular form, my lady.
Junior, one of my favorite pupils, Mr. Issa Mansour, is not the case that was not admitted. It is a response to your questions.
I thought we settled that.
We take off.
Number, we will compare it with the number
450M00204-133.
The time, please.
That one.
That reason that they chose to handle their differences diplomatically. Madam Chief Justice, these matters are contained in the affidavits. They further clarified that although they were willing to tolerate corporate governance infractions with equanimity, they were not ready to do that with regards to serious constitutional violations. There is no doubt that they were not involved in the tallying or verification of results at Bomas. The only thing that they would do is that they would be given results sporadically at the absolute discretion of the chairman to read, which they did, sometimes with embarrassing consequences, as were explained by Paul Mwangi in the morning. But they could not stand it any longer, Madam Chief Justice, when they were now being asked to sanction results, and they were not being asked, given information that they needed before they could sanction such results. The four commissioners were quite clear that they had a role to play. And they were quite clear that the results would not be delivered unless and until the winner is proved to have received more than 50 plus 1%. 50% plus 1 of the votes. All they were asking for, Madam Chief Justice, was information that could satisfy them that such constitutional provisions had been complied with. But that was not forthcoming. Instead, their request was construed as an attempt to moderate the results, and that is what they could not stand. Madam Chief Justice and honorable members, at this point, allow me to call Apple Mboya to come and explain exactly what kind of exchanges ensued earlier on between the four commissioners and the chairman. Thank you very much.
Your Ladyship, the Chief Justice and members of the court, the question that was asked, so that we are not accused of rehearsing a new case. The question that the court asked is that please show us that there were problems that was brewing. That is the question that the Honorable Justice Lenaola and the Deputy Chief Justice asked. Yeah, members of the court, if you look at the fifth respondent replying affidavit, Juliana Cherera, AC2 are memos. These memos are way back from April, when the chairman unilaterally caused the reshuffling and transferring of returning officers. And just to read one of 12th April of 2022, the three commissioners, that's Juliana Cherere, Justice Nyangaya, and Francis Wanderi, says as follows, addressing the chairman: we are specifically addressing your direct role in blocking our participation in corporate decisions making on the area of policy and oversight in the context of staff deployment. In that annexure, there are several memos going back up to April. That is almost 4 or 5 months after the commissioners had joined. Because of lack of time, and the only request I want to make to this court on behalf of those gallant 4 commissioners is that in your decision, you'll find a paragraph to shower accolades on these 4 commissioners for blowing the whistle to the infraction to our Constitution. And that the results that were read by the chairperson of the commission were dead on arrival. And since we have a self-confessed mortician, in our midst, we will appropriately request that the funeral rites for those results that were announced be performed appropriately. I call upon my colleague, Isa Mansour, to take over.
Good afternoon, my Lady Chief Justice, the DCJ, and judges of the Supreme Court. I'll very quickly go through the remaining questions asked by the judges. The first one, I think I'll combine them, and I'll just indicate who had asked these questions. The question by Justice Lenaola, whether the violence at Bomas affected the ability to announce the results of the 27 constituencies. The simple answer is no. My Lords, the position taken by the 4 commissioners is that there was opportunity, and as has been confirmed by my colleagues from the IEBC, to deliver those results in the morning. It was not taken, and the failure to announce those results in a respectful view triggered the scuffles and the protests that you witnessed. The next question that had been asked by the Honorable Chief Justice and the Deputy Chief Justice is whether the Commission was dysfunctional, and at what point did the Commission stop functioning as a corporate entity. The simple answer has been explained by my learned seniors, but the correct position is the Commission continued acting as a corporate entity, but it had serious corporate governance issues. And this is confirmed by the fact that they were able to deliver a general election, they were able to train presiding officers, so the Commission continued working as a corporate entity with the Secretariat and the team behind it, but they had serious corporate governance issues that have played out in the proceedings before this court. The third question that has been asked by the Chief Justice is what steps were taken, and this is, you'll find in the replying affidavit of the Vice Chairperson of the Commission. As early as April, as my seniors have said, when these issues about deployment of the election managers and presiding officers was brought to their attention, came to the attention of the commissioners, the matter was dealt with at plenary. And they wrote to the chairperson objecting and raising those issues and all the other issues, my Lady Chief Justice, that arose in the management of the affairs were dealt at plenary. The only problems you would note in their replying affidavits is that it's only when the chairperson took unilateral decisions in the name of the commission, that's where the problem was. And this is set out in paragraph 8 of the Deputy Vice Chairperson's replying affidavit. You'll have time to look at it. The third question, and this is a question that was not answered, was directed at the IEBC. I waited for that answer, it didn't come. I had posed it the other day. Why was the public display of results stopped? When you look at the replying affidavits of these 4 commissioners, all say the same thing. That public display was stopped by the chairperson, and they requested him to resume the display of the results, and he declined. What I was waiting for today was an answer from the chairperson as to why. That silence speaks volumes. The last question was the question that was asked by Justice, so that I can finish and give it to by Justice Smokin Wanjala, Supreme Court Judge. Why were the numbers important? The turnout. There's a simple answer to this. The voter identification is biometric, and where that fails, it's by the kit. So, my Lord, the IEBC has a constitutional duty to put in mechanisms to ensure there's no electoral malpractice. When you go back to 138.4 to determine who has won the election, the voters that were biometrically identified, the KIMS kits are configured so that they keep sending the information, which Mahat was trying to explain today. When the numbers come in from 34As, those numbers that are finally tabulated have to, because of the biometric voter identification, they must tally with the number of people who turned out to vote. So when you're looking at those, so when they give a percentage of the number of voters who voted, and you look at the tabulation in the final from 34C, those numbers have to merge, and they have to make sense, including the from 32As. That is why the turnout is critical. It gives transparency, and it helps to give credibility to the process. And that's why they have to tell the public, you have to know how many people are registered as voters, then you know the percentage of voter turnout, you calculate that, and then you can determine how many votes were cast, how many were rejected. All those numbers, when you compute them, they have to add up. When they don't, my lords, then there's a problem with that election. Thank you, and I think I will cede the ground to Senior Counsel to close it in the next 1 minute.
Very briefly, Honorable Chief Justice and members, Justices of the Supreme Court, on the issue of violence at Bomas and the impact and the character of these 4 commissioners, let the record of this honorable court show the following: that at the time preceding their walking out, the posting of the results on the screen had ceased, had stopped. So, all they wanted to know, these 4 commissioners, is to be given the opportunity to peruse the results of these 27 constituencies so as to satisfy themselves as to who the winner of the elections was, number 1. And number 2, whether that winner had reached the constitutional threshold of 50 plus 1. That's all they wanted to know. When that was denied, they had no option but to refuse to be a party to the violation of the Constitution. So as I sit down, let this record of this honorable court show that the results that were announced, the declaration, was not a declaration, just one. That declaration by the chair of the Electoral Commission was not a declaration of the Commission. Therefore, they are the majority, they do not support it, they ask for nullification of that declaration. I thank you.
We'll go first, Mr. Ngatia.
Madam CJ, I'll cede ground to the head, who was the former head of the bar, Attorney General, okay. Emeritus.
Okay.
Madam Chief Justice, members of the court.
My Lady Chief Justice, I have an objection to the... I have an objection to my learned senior's application, which he indicated earlier. My lady, we will of course be guided by your directions, but I rise to oppose the application by my learned senior, Mr. Gitu Muigai, to present evidence to controvert the submission by Julie Soweto. My Lord, my lady, the indication was that they'd been taken by surprise and should get a chance to present their view. They were not taken by surprise and can't be taken by surprise because...
My lady, if I may, this is a very awkward moment for me to interrupt the teacher who taught me procedure. I thought that one could only respond to an application that has been made, not before it is made.
Of course it has to be made before. The objection has to be made before.
Can I make the application now?
No, there's no point to it. He had indicated he was holding the application so that it has been indicated. So my objection is, and his own ground, that he needs to be replying to something that he had never known. He has, that picture was taken from the portal of the IEBC.
So he's not taken by surprise because it's their own picture on their own portal, and it's still there now as we talk, as we object. But secondly, this is the first time in many years that I have ever seen a party asking to rebut their own evidence. And that is an oxymoron that reflects accurately the state of their records. But I stand guided and would gladly withdraw my objection if the court wishes.
I think where we are coming from, Senior Counsel, our teacher, Mr. Firos Noronji, is that when the two forms were displayed, they wanted to respond because they said it's new evidence. And you saw the bench resistant to begin with, but we went to the records to find out whether it is among the forms that were submitted here, especially in the affidavits of Dr. Celestine, Mr. Arnold, and we found actually it is new evidence. That's why we allowed them. It is not an objection. It's a clarification because they said this is new evidence that they had not seen before. It is in that context.
Much obliged.
Yes, yes. So 5 minutes.
All is well that ends well. Mr. Mahat will give the explanation. Thank you very much, Milady.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Associate Justice of Supreme Court, I wish to respond to 3 very quick issues that were raised by my learned colleague, Ms. Julie Soweto. The first one relates to a form that was shown this court. I will want the form to be projected. We will. Whatever that was projected from the portal, that is what we want the court to see. What Ms. Julie Soweto showed. You could go, please go to Jose Camargo. I want to produce to the court the original form 34A.
It's okay.
Yes, you can see. It's okay. I want to produce the form 34A, the original form 34A, and I want to inform the court that the name Jose Camargo on that form is an overlay. Jose Camargo, the register of the QR code, that was printed by Smartmatic International, and it was printed in the name of Jose Camargo. You can show? The register is available.
We were very patient the way Mr. Mohammed addressed the court earlier. Very, very persuasive. But for good order and not to interfere with his submissions, we kept quiet. And if you look back at the record, a lot of what Mr. Mahat was saying was actually giving evidence. He was talking using the word we. This is how we do it. The trajectory which he is taking, without a witness to tell us the kind of information he's going to give us, is going to put the court in a very difficult position. I think he should transform himself to a witness, and we begin to cross-examine him. Because, and this is very serious, either we practice law the way we understand the law, or anybody can confront the court with any document at any time. I understood Mrs. Soweto to be giving an explanation in response to a question by the court. And similarly, Mr. Mohammed was responding to question by the court. And therefore, he had some latitude. But now we are entering a different universe where he is now going to produce evidence. He is saying how the picture was taken. There is no certificate, and this is electronic evidence accompanied by an original. I think it is very, very dangerous territory. And unless some clarity is given on this matter, it is going to be very difficult to operate from now.
My lords, what we are trying to do is to show you documents in our own affidavits in response to documents produced from the bar. Ms. Soweto never produced the document she showed you in any of her affidavits. When we now invite you to look at the original and to make the argument that my learned friend is about to make, that there is a deliberate misrepresentation of what the original document looked like. So we are treated to this attempt to block that fact from the court. This is not a legitimate objection. This is an attempt to interfere with legitimate evidence that is on record.
Let's give it directions, because we'll be here until tomorrow and we don't have this time. Senior counsel.
Yeah, just one point. And I'm normally very quiet, and I continue to be very quiet. But the good professor has misunderstood Ms. Soweto completely. It is not this document which is in question. It's the way the interference is being done. How this document is changed to another document twice or three times. I think the good professor will be doing a good service to the court. And if he is good coming to court with clean hands, he should first of all say, Mrs. Soweto, what Mrs. Soweto showed us today is not in their portal. That is the starting point.
Isn't that exactly
that is the starting point.
Bear with us, Senior Counsel. We've come thus far with a lot of discipline and dignity and respect to the court. The reason why we are here, and you saw us take a lot of time to reflect on the application that was made by, I think it started with Mr. Katwa Kigen, Mr. Kirago, and Mr. Ngatia. We resisted until we established from the pleadings that we have that these are new forms. And indeed, they are entitled to respond to them. So please, if you can just respond without taking us into anything else, just respond to those new forms, because they were not part of the ones that we have before us. We established that.
Thank you so much, Madam Chief Justice and members of the court. The difficulty we were facing in thinking about this, an allegation has been made as relates to this form, and there's an overlay of someone called Mr. Jose Camargo. What we were trying to show the court, that this is an overlay document, and we wanted to actually show the court where this document from Jose Camargo has come from. The document relating to Jose Camargo has come from the QR register, which is distributed to every polling station. And that document is even in the possession of this court. If you look at the scrutiny report, the QR documents are there. So what happened? Apio took an original Form 34A, he had the QR register, and he took a picture of it. What is the evidence that is being given in this court? That someone called Jose Camargo is interfering with this. And the point we want to make to this court is that if you look at the scrutiny report and if you look at the QR register, which is in those boxes, you will actually find the name of Jose Camargo on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Camargo was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Camargo was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court is should actually guide the court that actually that is not true. Why would anyone try to interfere with a portal transmitting, and the result he has is the same as what is in the A and what is in the portal? So to that question, we submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has. And in fact, we direct the court to the scrutiny documents. That register of opening and closing the KIM is there, and the name of Jose Camargo for purposes of audit trail is printed in there. Smartmatic Jose Camargo is printed there. So what has happened? Someone, a PO, took a picture on that one. The next point I want to make is the issue of the KIMs. We've been told there are 2 KIMs kit, which had the same serial number. And we understood our role to this court to give all the information to the court to make a decision. We admit that those KIMs have the same serial number. It was an error that originated at the time of the serialization. But we want to tell the court that those KIMs have different IMEI, they have different IP addresses, they have different polling stations, they have so they have different identifiers. And we acknowledge that that is an error that originated relating to those 2 KIMs. But there are other identifiers that can identify those KIMs are from our system. And we want to give that information to the court for purposes. Those KIMs are on their way to this court. We will give to the registrar of the court for the court to analyze and to look at it. And if you look at those KIMs, they transmitted the forms as required in the portal, and the A's also are coming, the original A's we will also give for those 3 forms. And our role is to give. The issue of transmission has come up. I just want to say this. There were 3 sets of transmissions at Bomas. One on the forms that has been downloaded, that was running properly. The second one related to the constituencies, that was continuing. The one which had stopped was the one on the tally. And the reason it stopped was, for 3 days, we had only verified 50 arrows. The process became clogged. For you to be able to transmit to the announcement, verification had to happen, then announcement happens. That means that those arrows have to be stopped, because verification cannot happen as announcement is happening. We will be running numbers that have not been announced yet. So because of that, and because of the audit, forensic audit that most of the agents were recommending, we had to stop that process to give verification a chance. There was nothing malicious about that. For those few remarks, Your Ladyship, I stand guided. Thank you.
Mr. Mahat, maybe we can have a look at the
My lady,
original
if the
34 that you are showing.
Sorry, my lady, Chief Justice, if the form can be handed over to the court. Excuse me. A moment. Thank you. Thank you. My lady, my learned friend, Senior Counsel Mulgore, has a comment after the court has seen the...
As you continue to look, we'd just like to make an observation. In fact, we are happy that the court receives the document, particularly the Form 34A, and everyone has been quoting Shakespeare and all the rest. I'll just quote some Swahili. Siku ya nyani kufa, miti yote huteleza. If you notice on the 34A, the UDA agent, the second agent, signed the form on the 7th of August, 2022, before the election. Before the election. I repeat, before the election. The other one as well, perhaps might have signed it on the 7th, but it's not clear. So that's all we wish to say.
While at it, Counsel, just before you go back, and when Did the other agent sign?
It looks like 7th, it looks like 9th. Only the IEBC and Mr. Chebukati can tell us. It is their evidence.
Before they explain, they would have to have something to explain.
We have let it go in.
This form, from the naked eye, of course, appears to have been signed by both agents on the same date. And the same date is 07.
Oh, 07 of 08.
07 of 08.
Yes, indeed.
See, well, I thought the point you were making was that the second one signed before the election. As though the first one, if I could just finish.
Okay.
As though the first one had signed on a different date.
No, our point is, and has always been, these forms may have been manufactured elsewhere, before, well after voting, and they all arise one day and they are counted. It is the mess that is IEBC, and it is the mess that is the 2022 presidential election that we have been emphasizing. Thank you.
You still want to talk?
Madam Chief Justice, my client is the one who is likely to suffer most in case these sensational matters are not dealt with effectively. Starting with the date, that is more of drama than reality, is seeing a speck in the other person's eye when the log is in the other person's eye. One of the things I think I ought to place on record is this. The forms that are now in issue have not been pleaded, were not tendered, and since they were not pleaded and they were not tendered, we should not be accused of not having responded to them. Point number 2, both agents have made a legitimate or have made an innocent mistake about the date. And I don't see where the laughter is emanating from. Point number 3, the form itself shows a contrary position to that which was sensationally displayed before this court. The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys. And that reminds me of that very unfortunate day in 2017 at 9 p.m. that again sensational claims were made about Forms 34B from Mombasa, in particular Shangamwe, made also to this court and which led to a nullification of a presidential contest. Madam CJ, there is also one more thing that concerns my client, because again, it has very prejudicial effect. It is what is definition of the commission. I will spend 1 or 2 minutes defining the various ways commission is defined in the law. Commission is first and foremost defined in Article 88. Commission is also defined.
If we open the matter now to other things, we will not see an end to this. You were responding to the 2 forms which were introduced.
As new evidence.
Yes, please don't go to other things that you are not supposed to, because we will not see an end to this.
I still have my time.
With respect, even if you have your time.
For the governor,
even if you have your time.
Thank you.
Just deal with the 2 forms.
So then, coming back to the forms, my request is this. Please delete from the... yes, the other thing is that all the form now before you has security features. The one that was displayed does not have. The one that you have does not have the name of Jose Camargo. The one that was displayed before the court has that name of Jose Camargo. The original one you now have does not have that name. And all those things were meant to deceive. They were meant to mislead.
We should never have to ask that we remain the way we started. We should never have to ask that.
Particularly from such eminent lawyers. The one that you have does not have any of those things that were displayed. My client therefore becomes quite concerned whether this case is to be adjudicated in the realm of falsehoods or within the parameters of factual contestations. That is a real concern. The minute we allow matters which are clearly false to infiltrate into the record of this court, we are likely to get into a very, very unfair decision. Let this case be decided on factual points and on factual contestations. We say the same about the second form that the original has not been provided. But as regards the second one, allow me to say this. Before this contest started, IEBC did avail to this honorable court all the forms 34As. All of them were deposited because we did see that correspondence. Consequently, as regards the second form, I would request this honorable court to find time to look for it, the certified copy, and in case, once again, it does not have this JAWS, whatever name it is, please come to this conclusion that a deliberate effort was made by counsel to mislead this court so as to arrive at a decision which would be most injurious to the first and second respondents. I'm very grateful for the 5 minutes, and I rest.
Thank you very much. With your permission, we would like to go to another segment of these proceedings, the last of them, where we'll be considering the report from the scrutiny or the discovery that was undertaken by the court, and I'll ask the Honorable Lady Justice Joki Ndungu to take us through that session.
Thank you very much, Madam President Judge. Before I come to the issue of the exercise before us, I just wanted to assure Senior Counsel Paul Mwite that when the 14 days start running, and we are guided by Article 259, when we do work Saturdays and Sundays. So as soon as the time is triggered, in fact, the judges are working all the time. You're the ones who get to go home and rest. When you rest, we go and we continue to work. Thank you very much. So just before we proceed with the next session, it was just a summary of the order that we gave to parties and the rationale for those orders. We received 3 applications from 3 parties, from the Youth Advocacy Africa. We received an application from Khelef Khalifa, and we also received an application by Raila Odinga and Martha Karua, in which we were asked, the press was sought to undertake scrutiny and access to certain information. After we looked at the applications and the prayers, we then looked at the pleadings and the affidavits to ensure that the prayers matched with the pleadings and the affidavits that have been filed by the petitioners. As you will recall, the the court then determined the issues which we will determine, and that also helped us set out the orders for scrutiny, so that our orders were set out based on the pleadings, the affidavits, the issues for determination. But further to that, we also did say in the body of our order that we would not encourage a fishing expedition, and that the request needed to be specific, and that given the 14-day timeline, the court would only allow reasonable, practical, and helpful orders. We also acknowledged that under Section 12 of the Supreme Court Act, the IEBC has already submitted all the Form 34As, and therefore they could be accessed in the court. We also stated that some other issues, some other things that had been requested for in the prayers are in the public domain, and that parties could then get those. We did note that some of the requests or the prayers were unrealistic. Some of them were general and vague. Some of them involved parties that were not enjoined to be before us. And therefore, we granted orders not based on prayers, but based on what we assessed that the court needed to look at in terms of all those criteria that I have set out. And therefore, the exercise that was conducted under the hand of the registrar followed strictly the orders which were given under the hand of this court using that criteria. I think that is a fair summary. Madam Judge President, I will stop there.
Thank you. I think an exercise was carried out, a very rigorous exercise led by our registrar. Indeed, these are people who had not slept for 24 hours working to carry out this exercise of ensuring that there is compliance with the orders of this court. Our staff actually spent a night here. They had to shower somewhere here and continue working yesterday morning. So the report has been shared with council online, and because the parties who are involved in the requests for the discovery is the main petitioner, the Youth for Advocacy, and the petitioner Karif. We have decided to allocate each one of you 15 minutes to submit on any issues you like us to take note of in the report. That is the main petitioner, 15 minutes. Youth Advocacy for Africa, 15 minutes. Karifa, 15 minutes. Then we will have IEBC, 15 minutes. And because the first respondent is also affected by what is being discussed in the report, we also agreed to give them 15 minutes. Yes, you have the floor.
Thank you very much, Your Ladyships and my Lord. I'll be as quick as possible, and I would like to indicate that I will share the time with my colleague Jackson Awele, who will deal with what happened at Forodha, while I will deal with everything that happened at IEBC anniversary towers. The report the court has given runs into 178 pages, but we worked overnight to provide written observations to the court, which we filed this morning, and so all parties are actually aware of whatever it is the first and second respondents, petitioners have observed. Very quickly, IEBC confirmed that the RTS, the results transmission system, runs on 8 servers, of which one is a virtual server.
Counsel?
Yes?
You say you filed something?
Yes, we filed written observations with court, and we have a few copies.
Just wait until we get our copies. Are they in the bank?
We filed them
just
before.
give us
Okay.
a moment there. If you say you have extra copies, you could give us, yes, so as to save on time.
Yes,
we do not have a copy. If Learned Counsel could be kind enough and serve us a copy.
For the principal respondents, we can give you one of each.
This shows the time we are given to respond.
We served them before 9 o'clock this morning. Electronically. The only thing that there'll be a problem is some of the images will not be very clear, but when you do have time, the images at the end.
Just hold on, Counsel.
Okay.
You could start.
Yes, Jackson, you could also perhaps upload it so that those who don't have a copy can see where we're reading. I'll go to the first observation on page 2, summarize the first paragraph. IEBC confirmed that the results transmission system runs on 8 servers, of which 1 is a virtual server, and the 7 are Docker containers, which is a server within a server. The IEBC denied agents access to the Docker servers. We were therefore unable to proceed further with that exercise. Paragraph 2. The
Counsel again.
Yes.
The copies you've given us are not filed.
They're not filed, the electronic ones are filed. I anticipated having to provide 1 or 2 people with copies, but the electronic ones are filed, very clear. We have a receipt.
Yeah. It's all right.
Okay.
Counsel, I think we had already given directions that we expect oral submissions.
I am making oral submissions.
Yes, so okay. I'm just saying, let us not worry too much about written reports, who has served who.
Okay.
You're letting the court know what you think of the exercise so that we can take those submissions into consideration. And that should apply to all the other parties.
I stand guided. Thank you very much. I go to paragraph, or I'll just make it an oral submission. The virtual image availed for scrutiny was created on the 31st of August 2022. We therefore state that this cannot be from the same server that ran the just concluded general election. And the image of the server was not provided. The further major observation we make, the KIMS kit was not availed for scrutiny to establish the availability of the embedded scanner application that would verify the image format. So the IEBC declined to avail the system documentation. I go on. There was very disturbing evidence of log deletions from the IEBC server that was availed, in part, partially availed. These deletions occurred on the 6th of August 2022, which is 2 days before the contested election. We observe that, surprisingly, the registrar's report at page 21, issue number 5, indicates that there were no deletions. We think this is a mistake. It should be looked into. The effect of the deletions, we can upload that. It's on the screen now, that we were able to get from IEBC, indicates that, and this is image marked 15, that at the material time, foreigners, including Ogudino, Vito, J. Carmago, Josio, were operating the system. Those are 5 foreign individuals. If a forensic image of the server is availed, details of what was deleted would certainly be established. The other major observation, IEBC refused to provide a security walkthrough to highlight key security controls to determine whether Form 34A could be tampered with during transmission, at what point. So we hit a dead end, contrary to what their counsel repeatedly says. They are transparent, it's available. They are even giving the court, donating to the court Keame's kits to look through. Finally, or well, not finally, IEBC refused to grant access to the forensically imaged servers. Instead, the server administrator projected the vSphere, which is the Virtual Server Application Management System, on the whiteboard to demonstrate the access to the servers. The vSphere indicates that the virtual RTS server was created and modified on the 31st of August at 2022. In effect, no information from a server was provided to show what happened during the 2022 general election. Number 11, a couple of manuals were provided, or bundles of documents. We'd like to point out that of interest to the court would be that at page 77 of one of the manuals titled Information and Communication Technology ICT Policy, at page 77 and 78 is a list of 77, a list of 41 individuals, starting with Dixon Kwanusu, and second one Abdi Dahir Abdi Malim, who are described at the top of the page as national returning officers, an office unknown to the law or the Constitution. I would request that the court takes note of that in particular. And paragraph 14, on the 1st of September 2022, the deadlock over the servers finally came to a head when IEBC wrote to the Registrar of the Supreme Court enclosing a letter dated 31st August 2022 from Smartmatic International BV, the same company that Carmago comes from, enclosing in which the letter states, amongst other reasons, the image of the NTC servers containing software owned and copyrighted by Smartmatic and thus IP protected. Providing full access would infringe our intellectual property rights. That brought to the end that matter. Smartmatic, Carmago, whoever they are, wherever they are from, have indicated that they will block and refuse access to the servers completely. I then move to the images. Certain images were shared by IEBC. I'm not certain that they were aware of what they were serving. There was always staff that seemed quite unqualified in whatever they were doing. They couldn't operate the systems or pretended they couldn't, but they did share image number 6. The first image I showed was the image of deletions, but the one I would like to focus on in this very limited time is image number 6, which is several, about 1, 2, 3, 4, 5 pages of logs. The logs are from the RTS server, results transmission system, on various days leading up to and after the election date of the 9th. In particular, 15th July 2022 to the 16th of August 2022. And I must apologize to bring the bad news not only to this court, but to the entire Republic, that those logs contain active participation of foreigners on the results transmission systems of IEBC from the 15th to the 16th of August, 15th of July to the 16th of August 2022. Their names are Vito, Josio, that is the names identified in these logs, Josio, Ogudino, Sisiva, Provisio, and Jacamargo. The copies I provided to the court are much clearer, and you can see the names, you can see the times, and of interest, and I will only highlight certain entries, only the longest entries. I will start by saying those 6 individuals, foreigners, in the Immigration Act, they are also referred to as aliens, accessed this server 180 times or thereabouts. The longest being Scamago on the 8th of August 2022, Josio, let me deal with the time. Josio on the 9th of August 2022, which is the election day, for 1 hour 32 minutes. Ogudino on the 11th of August 2022, 2 hours 54 minutes. Ogudino again on the 11th of August, 3 hours 16 minutes. Ogudino on the 14th of August 2022 for 2 hours. Ogudino on the 4th of August again, 1 hour 57 minutes. And then the 16th of August, Ogudino, 1 hour 1 minute. I close by saying, what a mess, what a mess. My learned friend Mr. Ngatia struggled so hard to get Mr. Camargo out of the mess of taking control of our elections in the case of the 34A we've just been talking about, but we have caught Mr. Camargo and all his friends in our election process before, after, and where are they? Only God knows, and only the servers will show us. History is repeating itself. 2017, Mr. Chebukati refused to provide access to the servers. He's doing it again. And of course, please, I ask the court to take note of everything we have provided as far as the DCI has provided to us. We have provided to the court. These are individuals whose identities are not even known. They travel on, or they provide expired passports when interrogated by the police, and all the rest of it. I would not repeat any more of that. On the 8th of, yes, I'm happy to be pointed out, the logs will also show that on the 8th of August 2022, Camargo accessed the portal while in Venezuela. So our elections were conducted from Venezuela. The Venezuelans decided who won. Mr. Chebukati was just the mouthpiece. Thank you.
My Lady the Chief Justice, my Lady the Deputy Chief Justice, my lords, my ladies, in the remaining few minutes, permit me to take you through our report from the scrutiny exercise carried out at Forodha. And my lord, I'd like to very quickly just highlight sequentially in the order in which the ruling was made.
Did we get your name for record purposes?
My apologies once again. Jackson Awele is my name, my lady. My lady, in the order in which the ruling was given, order number 5 granted the applicants inspection, scrutiny, and recount in respect of 45 polling stations. There were about 16 polling centers, and within them we had 45 polling stations. Now, in conducting the exercise, our focus was on qualitative aspects of the results and the electoral materials that were deposited in the ballot boxes. And one of the things, if I may start from where Mr. Mahat left from, that we were looking out for were the QR codes of the KIMS kit in tamper-proof envelopes and Kim's validation Form 44 in tamper-proof envelopes. My learned friend, Mr. Mahat, has urged you to go through the scrutiny report, and that in that report you will find information and evidence about the QR codes of all the Kim's kits and in respect of the ballot boxes that were submitted to you. We hate to submit to you, my lords and my ladies, that in your report you will only find one QR code and one Kim's validation Form 44 that was submitted or that was found in the ballot boxes that were submitted for scrutiny out of the 45 polling stations that we scrutinized. Of all the other ballot boxes, the QR code of Kim's kits in tamper-proof envelopes and the Kim's validation forms, Form 44 in tamper-proof envelopes, were missing. The question is, where were they? In light of Ms. Soweto's submissions, your guess is as good as mine. We also looked for the pasted carbon copy of Form 34A in the ballot box, and in all the forms, or rather the ballot boxes, we did, or rather the book 2 of Form 34A was only found in 27 out of, were not found in 27 out of 45 polling stations. And as a matter of fact, my lords and my ladies, if I had time, I would go through the list, but this represents 50% of the ballot boxes that were submitted to us for scrutiny, missing book 2 of Form 34A. Now, in Vita Primary School, the other electoral material that we looked for was the Form 32A that evidenced voting by using the manual register. In Vita Primary School, Station 7 of 7, 232 people we noted voted using the manual register, and no Form 32A was submitted in respect of those votes. In Vita Primary Polling Station 1 of 7, 260 people voted using the manual register. No Form 32A was availed to verify that indeed the authorizations that the IEBC stated should be given before voting by manual register were indeed given. Finally, my lords and my ladies, in respect of the Form 34A, the carbon copy of the result that went out. My time has run out, my lord. If I may just make that point in 1 minute, with your kind permission. In the 27 polling stations, in the 27 polling stations that we noted did not have book 2 of Form 34A, they also did not return the carbon copy of the actual results emanating from those polling stations in the ballot box. In other words, the results or the ballot papers in those ballot boxes could not be verified with the carbon copy of the original Form 34A that was used to declare the results in respect of those polling stations in these presidential elections. For those and all the submissions made by my learned seniors and Mr. Murgo, my lord, I thank you for your time and pray that the petition be allowed to spread.
May it please your leadership, the Honorable Chief Justice and distinguished members of the Supreme Court. My name is Njomo. I do appear for the third petitioner, who was originally petition number 2 before in the consolidated petition. Your leadership, I'll make a brief comment on the report of scrutiny, and I'll focus on the scrutiny that happened at the floor of the House. And my learned friend Njoki Mboshe will focus on the scrutiny at the IEBC offices at Anniversary Towers. Your Leadership, we have looked at the report as a result of the scrutiny, and we have isolated some few issues that will urge the court to consider in perusing the report. And one of the notable issues, and I concur with what my learned friend Mr. Awele has observed, is that we came across in a process that I personally participated in what learned Judge Justice Njoki has observed, that it is a process that took more than 24 hours. We came across ballot boxes that did not have original or carbon copies of Form 34As. Your Leadership, the effect of that is that the authenticity of the forms appearing in the public portal is then called to question. There are ballot boxes, for instance, I'll give the Mikindani Primary School, polling station number 8 of 9, the report is appearing at page 81, where it is clearly observed that it did not have the Form 34A. We also have another polling station, that is Chepkulung Primary School, 3 of 3, that did not have the Form 34A in the box. So that then the question arises, where is the source, or what is the authenticity of the Form 34A that is displayed in the portal? Because there's nothing to compare with as required by the regulation. Another notable issue that we came across, Your Leadership, is that there were ballot boxes that did not have seals matching what is recorded in the polling station diary. My lady, what happens is that at the close of polling, one is required to record the seals that are then affixed on the ballot boxes when they are closed. So that the record of the ballot seals as appearing in the polling station diary, when they don't match what is actually presented to the court at the point of scrutiny, that raises eyebrows. Because it happened in one primary school, you note, Your Leadership, from the report, at paragraph, page 53, Majengo Primary School, it's observed that in the report that all the serial numbers had been altered. The effect of this, Your Leadership, is that we cannot then be sure at what point is the ballot box opened, so that those seals that were affixed at the close of the polling were changed. Alteration of seals is a serious breach of the regulations that govern elections. Your Leadership, another observation we made on the broken seals is with respect to Keheo Primary School in a constituency called Ojorok in Nyandarua County. What the report by the registrar of this Supreme Court notes is that the aperture, this is where the ballot paper is slotted in, putting in the box, had a seal that had been replaced. The seal that was noted at the close of polling and the seal number on the aperture at the point of scrutiny had been altered. This is noted, Your Lordship, my lady, at page 146 of that report that is before the court. The third issue that we also noted is as regards Book 2 of 2. My lady, the Chief Justice and distinguished judges, Book 2 of 2 needs to be put in context. That the IEBC printed Book 1 and Book 2 of Form 34As. When that was discovered, the IEBC indicated that Book 2 of 2 will not be used for purposes of reporting presidential elections. But then the assurance that the IEBC gave was that that Book 2 of 2 will be deposited in the ballot boxes and it will not be utilized. Unfortunately, at the point of scrutiny, there were 27 polling stations from the 45, or rather 47 that were to be scrutinized that did not have Book 2 of 2. The question then that begs our minds is, where did the Book 2s of 2 go? Were they used to report results, presidential elections, or where did they vanish to? Because the factual position is that those Book 2 of 2s were missing in at least 27 of the polling stations that went through scrutiny in the process that we undertook. My lady, another issue, and the honorable judges, that we came across is that there were missing counterfoils from the ballot boxes. The requirement under the regulations is that when a ballot is slid from the main booklet, then at least a counterfoil will remain. The purpose of scrutiny will then serve some purpose if you compare the counterfoils against the number of votes that were cast, including the rejected votes. But, my lady, the Chief Justice and judges of the Supreme Court, without the counterfoil being present that you can compare with, then a question then arises as to whether those who are actually the ballots appearing in the ballot boxes were torn from the booklet, because there's nothing to compare with. Counterfoils were missing, my lady and honorable judges, from Keheo Primary School. This is noted at page 146 of the report, from Keheo Primary School, polling station number 2 of 2. My lady, there were myriad of issues that we came across. In addition to that, with the scrutiny, envelopes, electoral material, these include the ballots that have been cast, the counterfoils that have been used, the register in the polling station, all those electoral materials that the regulations require that they should be deposited in the ballot box in tamper-proof envelopes. But unfortunately, what we came across was that there were very many polling stations, from the ones that we undertook scrutiny, where all the contents, the electoral material, were not placed in tamper-proof envelopes. And just to give an example of a few, we had Muvita Primary School in Mombasa, that this is noted at page 34 of the report. Polling station, also Muvita Primary School polling station 7 of 7, there were 7 polling stations. That happened also in Mikindani Primary School, polling station number 7 of 9. This is noted at page 80 of the report. We have Chebukati'S Primary School, polling station number 1 of 3. We have Kapsusel Primary School, polling station 1 of 3. That you find in the ballot box, the materials are there, but they are not placed in tamper-proof envelopes as required by the law. Your Ladyship, we look at those anomalies in line with the provisions of the Elections General Regulations of 2017, and specifically regulation number 81, that require this electoral material to be placed in tamper-proof envelopes and then sealed in a ballot box. When that happens, it is a clear breach of the regulations as required. And then these anomalies, again, it is my humble submissions that I also speak to the requirements on the Article 86D of the Constitution. And, my lady, this is clear because it requires electoral system to be accountable, and even requires the IEBC to preserve electoral material in a safe manner. When this has not been done, Your Ladyship and honorable judges of the Supreme Court, we submit that that is a clear breach of the Constitution, and no accountability can then arise in the event where such issues have arisen. Your Lady, my lady, having spent my minutes on the issue of scrutiny at further, I'll now hand over the floor to my learned friend, Joachim Bosche, to comment on the scrutiny of the technology process. Thank you very much and appreciate it. Thank you.
My Lady, the Chief Justice, honorable judges of the Supreme Court, I noticed that the time was still running as I was walking here. I hope I'll recover my seconds. As my learned brother has indicated, I'll be going through briefly what happened at Anniversary Towers. Just to add that, my lady, we have already seen the gaps from what my brother, Mr. Njomo, has said. The breaches, the illegalities, and the gaps that were there in the collection, the tallying of the numbers. My lady, what we have been told by the first and second respondents, as you will see it happening even as we went to Anniversary Towers, is the attitude of get over it, it's over. Because, my lady, and as has been ably submitted by my learned senior Mr. Mulgore, when he was talking about what happened at Anniversary Towers, we were denied access to the server. Our agents were denied access to the server. My lady, and honorable members of the court, when you retire, you will see at page 8 of the report, item number 4, that they said the best they could do was to give us a clone image of the server. When we said, let's proceed, or when our agent said, let's proceed, it became clear that to generate a forensic image, there was the requirement for the development of what is called a forensic image hash. My ladies, honorable members of the court, it was then asked for the IEBC because they wanted to give us this clone to generate the hash. What did they say? They said, oh no, the judiciary should generate the hash. Yet, it is the system that they are calling upon us and Kenyans to believe they were in control of. They have no idea how to generate those things, and if they do, they want to take zero responsibility for that job. And that is why, contrary to the requirements of the Constitution, the IEBC abrogated their duty to conduct the IT component of the election and gave it entirely to Smartmatic. And that is why Smartmatic wrote a letter further to the directions of this court, that letter was served upon our firm yesterday. And the letter is dated 31st August. On the right, and this letter should be before this court because it is addressed to the registrar. So I expect, Judge, honorable members of this court, that it's before you. Clearly, it shows it is from Amsterdam. And it says that they will not give us access to the servers because it infringes on their intellectual property. What Mr. Macharia called today, the question of what happens to our data. We cannot even verify the election, contrary to the requirements of the Constitution that it should be verifiable. When the Honorable Court gives orders for scrutiny, Smartmatic says they cannot give us that access. We have set it out. It's set out in the report that has been placed before this court, and the letter is there to confirm. What they then go ahead and do is to amend the orders of this court. And my ladies will see when you read that letter that they say that instead, they would like to recommend that the IEBC makes available, and they say the documents that they want IEBC to give us, including some system logs, which, as Mr. Murgor has indicated, not all those system logs were provided anyway. And the ones that were provided, we saw who had access. Our agents did indicate that when we asked, because this becomes very important on the question of access, and that's why the logs become important as well, when we asked, as the court had directed in its ruling, order number 1, that we get a password policy, they said no, it will infringe on the security. And that becomes extremely important in terms of knowing who had access to those servers, in terms of confirming the the code or the policy on change of passwords. They refused to give that information. Again, IEBC refused to give us information with respect to the RTS, Results Transformation Systems. Yet they want us to come here and believe what they're telling us with regards to the contents of the portal. Yet in their own Gazette notices, as you will find, there were some points where there was human intervention, and that is why they are unable to explain to this court, which we asked them to do and they were unable to do, to explain how the JPEG photos, my ladies, 2 more minutes? Thank you. They are unable to explain how an image is taken but ends up on the server as a PDF. In their own Gazette notice of 3rd August, which is part of our evidence, the petitioner in 002, they said that in some certain areas, returning officers will be allowed to take photos using their phones and transmit the same to the tallying center. So how then is it that all the photos on the portal are in PDF, and yet they refused, they declined and dishonored this court's order to give us information on the results transmission system? My ladies, my lords will find, when you look at the report that has been submitted, page 11, the judiciary report, that they refused to comply with orders number 1, they refused to comply with orders number 4, they partly complied with order number 3 and number 4. Honorable members of this court, the ICT scrutiny was anchored on those 4 orders. They therefore failed to comply. They refused to open the server. Smartmatic wrote, and to the best of what they could tell us, in addition to amending the judgment, they also say at the very end that even citizens all over the world had full access of these tally reports and were able to add the results, telling Kenyans, we have no additional claim of that information. We can tally like everybody else. It is our humble submission that IEBC abrogated their duty. IEBC was not in charge in terms of the technical component, and that is why my brother Willis said they played picky, ponky eventually to determine who won the election. Kenya's electoral processes run outside Kenya. We humbly submit that there was non-compliance. We humbly submit IEBC failed the test. Kindly allow our petition.
Before I start, we were served with a letter just for housekeeping purposes. We were served a letter that my learned friend has referred to from Smartmatic. It was addressed to the registrar of this court. So for parity of arms, we will wish to also make reference to that letter as we submit. First thing I must say this. IEBC, in the report by the registrar, I'll start from page 17. Here the registrar says, forensically captured, compliance task, forensically captured image of the server holding form 34C, not provided. We move quickly to page 21. Virtual server image. All agents were interested in knowing the virtual server creation date. It was established that both the creation and modified date for the image was 31st August 2022, though the technical team at IEBC could not locate the correct data store for the image. Very important. Page 22. The agent requested IEBC to provide certified copies of penetration tests conducted before and during the election. IEBC director, ICT director and IEBC advocate provided certified penetration tests conducted before the election. IEBC advocate informed the applicants that IEBC did not carry out penetration tests during the election period, citing penetration tests are not conducted during the election. That is very important, and I asked the court to find out why it's important to conduct penetration tests. At page 24, it was asked, it was noted that the containers running in the virtual machine are actual computers. IEBC declined to share further details on the containers. Ask your expert why they refused, and they'll tell you. At page 25, what was the IEBC password policy on the server? The response, captured by the registrar. IEBC could not display for security reasons. Number 31, the agent wanted to know why the user says logs in from server 192.168.95.64. There was no proper explanation for this issue. The agent requested to know if the antivirus or anti-malware was installed. IEBC did not respond. What am I trying to say? Just even from the basic information that was provided to the agents for the scrutiny, IEBC successfully exposed how vulnerable our system was. And for the first year, IT students, I'll give you they can take down note what IEBC gave as the memory, the capacity of the server that was provided. Memory was 6.4 GB, clock speed was 9.84 GHz, hard disk was 300 GB. The server specifications that they provided us with is less than even the laptops that we are using here. That is what they are presenting to us, that they were hosting the entire election infrastructure in these elections. It was not possible. Why I put that image? It's very important we know. I talked about the middleman, Diego Armando Camargo, distributing results. That is the person who you are not allowed to see. That is the person who, when the Supreme Court makes an order to be allowed complete access, to be provided the password policies, that is the Diego Camargo who we are being told you cannot access him. That back office, polling station goes to him. He's the one who sends to the returning officer. He's the one who sends to the National Tallying Center. He's the one who sends to the public portal. He's the one controlling everything. He's the midfielder distributing to everybody the results of this election. What he says are the results. You can now remove the portal. You can remove it, please. Having said that, we must note that as the world evolves, technology in elections also evolve. Previously, when my learned senior James Orengo was running in 1979 in Ugenya, people used to stuff ballots and run away with them physically. Progressively, they start changing forms. Now, elections are stolen on technology. That's why I said machines are voting for us. I refer you to a case that I've mentioned in my authorities, Dr. W versus the German Bundestag, where the Germans asked themselves, are the Germans really voting or machines are choosing our leaders? And they said, if the technology does not meet the thresholds of our constitution, do away with that technology until it conforms. In this particular case, we've demonstrated through the registrar's report that the technology that we deployed in this election, even this Supreme Court cannot access it. This Supreme Court order was countermanded by the letter which I have referred to, dated 31st of August. We would like to clarify that such images contain software owned and copyrighted by Smartmatic and is thus IP protected. Providing full access will infringe our intellectual property rights. This court can make orders even to our most highest National Intelligence Bureau. And those intelligence agencies have provided to our courts under cover or confidentiality their intelligence reports. Why can't Smartmatic do it? Why are they ignoring the court order? Why are they saying we'll not give you? Then they go to Venezuela or wherever they are and keep it to themselves. Are we going to ignore it? I pray that we do not. If it reaches a point that elections are not transparent even to the Supreme Court, and I draw inspiration to the provisions of our laws that provide once a petition is filed, the entire infrastructure of that election, ballot boxes, ballot papers, forms, are submitted to the courts. Ask yourselves, have you been given access or have you been handed over to as a court the entire election infrastructure for the presidential elections 2022? The answer is no. It is in the hands of the Smartmatics, and they've said they shall not give you. Do what you want. On to the scrutiny. And I thank you very much, my lords and my ladies, for allowing my application for Form 34A, Book 2 of 2 to be provided. This is the reason why we asked for that form. And I'll show you the mischief of what happened. In 2017, the basic ground upon which this court was able to expose the irregularities was through the fake forms. Fake forms were used in the elections. Remember, ballot is the currency, forms are the returns of that currency. What did Chebukati do in this election? He decided to print genuine forms in excess. He printed deliberately without a commission resolution genuine forms in excess in all the 46,000 polling stations. They were not needed. What did he end up doing when the party agents raised it? Mr. Chebukati proceeded to send them to all the 46,000 polling stations. All those 46,000 genuine forms, book 2 of 2. So in your electoral universe, you are now parallel to the genuine forms from book A. You also have another set of genuine forms, book 2. What has the scrutiny disclosed to us? It has disclosed to us that 50% of book 2 was used. I had requested that we be given book 2 in the entire country. And the court in clarification said, limit it to the polling stations in Ms. Celestine's affidavit. And I took it. It has confirmed what I believed actually happened.
Mr. Chair, please point us to the report where that is captured.
No, the reports, oh, sorry. The numbers are found from page, the registrar has not given you the tabulation of percentages, but from page 175.
You see, the submission you're making comes from the report.
Yes.
So we'd like to find from the report where that 50% appears. That's
Okay, the 50%, if you look at from page 175, sorry. It gets to 50% when you add them. You must do the addition. There are 27 polling stations.
In the report?
The word 50%?
Yes.
I can mention the polling stations.
But it's not in the report, it's your calculation.
My calculation, yes, it's my calculation, based on what the registrars found. Like if you find, for example, Kakamega High School, there was no form provided. For book 2 was never provided. Bomet County, Gorgor School, polling station 2, not provided. Kasagik Primary School, polling station 1 forms not provided. St. Joseph Kapkerich Primary School, the form was used. Chesentum Primary School, form was used. Kamwai Primary School, form was used. So if you add up from the registrar's report, they come to 50% of those forms that went out. Now, to explain it in a layman's language, because this is very important that we understand. It's like saying, I have printed for every polling station 700 ballot papers. But 100. Then you send all of them to the polling stations. And you issue a gazette notice telling polling stations, when you receive the ballot papers, please return to me 700 untouched. Only use 700. What do the polling presiding officers do when they receive these ballot papers? They decide to liberally use them. So that when you go out to find out where the mischief is, the system is muddled. He has thrown at you so many ballot papers, you cannot know the genuine and the fake. Mr. Chebukati single-handedly directed for book 34(2) of 2 to be printed. And book 2 of 2 having been printed, it went out to the stations. The gazette notice required it not to be used. It was used, and the registrar's reform has confirmed. How does it work? Let me use a real-life experience of a movie that I watched, because I have time. It's called The Italian Job. Once they conclude, when this gentleman steals and he comes with many lorries, and you can't tell which lorry has the actual cash, similar number plates, similar design, similar make. So it's meant to confuse you, don't know which is the actual truck that has the money. In simple terms, if I steal money on this table, I steal 1 million, I throw 200,000, all of you scramble for it, and I walk out with 800,000, leaving all of you scrambling for the 200,000. You'll never know the magnitude of what I have done. That is the magnitude of book 2 of 2 in our elections. The best example before I cede my time to the court, if you've watched The Wolf, it's called The Wolf of Wall Street. When the star player, at the point of blowing it all up, throws money at everybody because he has now made his ultimate loot. He throws money at everybody, and no one can tell what actually transpired. That is what happened with Book 2 of 2 in our elections. That when you start questioning, when you start tracing, you will only be meeting genuine forms. In 2017, when we were questioning, we were meeting fake forms. He threw an extra 46,000 genuine forms into our elections in the hands of people who could not account for them. When we went to look, we were able to demonstrate that 50% of those forms have been used from a sample. From a sample, not denied, either not used or not accounted for, not returned. Are we going to give regime legitimacy after this indicting audit report? I asked this question in the morning. Part of the Supreme Court's function, you give what we call regime legitimacy. The Kenyan people moving in one accord. And nobody has spoke in this court about the margin of victory that is declared. Less than 200,000. After all these muddled figures, after all these illegalities, are we going to say that let us ignore them and give a regime legitimacy to one of the players? I urge you not to ignore your registrar's report. This is too damning. This has confirmed to you that at the end of this process, the only person who could answer the question where the punk was going to land was Wafula Chebukati himself. It was not the instruments that were deployed for the conduct of the elections. I thank you very much for the opportunity to appear before you. Thank you for listening to me. And I thank Justice Wanjala today. He didn't respond when I did my monk. Can I donate my time back to the course? Thank you.
You also did not sweat, so we are okay.
IEBC.
My ladies, my lords, Mr. Dennis Nkarisha will make the presentation for us.
Thank you, Senior.
Repeat your name for us.
Dennis Nkarichia, Nkaricchia. If I may proceed, my lady.
Yes, please.
I would like to refer the court only to 2 documents generated by the registrar. There is a list of annexures that has R1 and runs for 42 pages, and there's a big report of page 1 to 178 that covers the entire report. My lady, I'll take you to page 15 of the registrar's report, which provides a table to determine whether the IEBC complied with the scrutiny orders. On the issue of ICT, my ladies, I'll do order 1, 2, 3, and 4. My lord and senior Mr. Wetangula will deal with the rest of the orders. My lady, for order 1, we fully complied, save for providing the owners of system administration password. The order issued by the court had a security exception, but if it was determined it was too risky to provide something, we were to object and provide an explanation. My ladies, my lords, we objected because those persons once identified, their personal security could not be guaranteed in any way. And that explanation was accepted by everybody. The rest of the documentation that Senior Counsel Mugo said were not provided, my lady, that report says they were provided. The password policy is number 1, the password matrix is number 2, the system users and level access is number 4. Those documents, my lady, were provided, and the registrar noted the same. On the second order, my lady, the one about the server, my lady, I'll come back to it, but there's only one server. Senior Learned Counsel, Mr. Mugo, was economical with the truth, and I will develop it in the responses and queries raised by his agent, Mr. George, who is identified in the annex that the registrars provided. Mr. George is in R2, and he appears as George Joroge, the 13th person in that list. George Joroge, he assigned, he was his agent. So, my lady, access was provided to the server. And indulge me, I read something that was noted by the registrar on page 17, supervised access. Agents were granted supervised access to the live server through an interactive session. All their concerns and questions were exhaustively answered through querying of server for logs, not by mouth, not by explanation, by their own queries to the server. My lords, my lady, I was there. Mr. George, for the petitioners, dictated specific queries. They were run in the system, and he was completely satisfied. That is the registrar's comment, not the IEBC's comment. As such, the statement that they were denied access is factually inconsistent with the registrar's remarks. Secondly, my lady, the demo of the IEBC system architecture, the theory is proven by the registrar. IEBC provided a demo of their election infrastructure for agents to understand. We were not doing it in vacuum, my lords, my ladies. I will leave the comment on the server, my lords, my ladies, for later on. I will now just show compliance. On order three, from the registrar's report, my lords, my ladies, it was fully complied. You can look at the remarks by the registrar, and it says provided. And critically is the penetration test, what is known as the pen test, under the election technology regulations, regulation 10 and 11, but Senior Mugo said was not provided. My lady, I'll take you to page 18 and 19. Supreme Court Order 3, penetration test reports prior. IEBC provided report on internal network and infrastructure vulnerability and assessment, and certificate of penetration were provided to the applicants and the first respondent. Volume 2, page 1 to 51. It's not a theory. A document was granted, and it had 51 pages. My lady, on Order 4, I can confirm we personally filed under seal all partnership agreements with the court, and the registrar notes as much. So, my lady, contrary to the assertion provided in public by counsel, we fully complied. And the only issue we never complied was partnership agreement provided to court under seal. And the issue of server, yesterday at 1:02 p.m., the court and all parties were issued with a forensic image of Form 34C had delivered and by email, my lords, my ladies. That was compliant. And it had a hash key. And it had a certificate of forensic evidence generated by Martin Nyaga. There is a certificate in court, my lords, my ladies, that the hash key was provided. So rather than move to generalization, at a granular level, we can prove we fully complied with the orders on ICT. Now, I'll pick issues on the party interrogation into the system. And I want to pick issue 1, it's by George. The same George, I said, is an agent of Mr. Mugo, and is proven by the registrar's report R2, the person under 13, for Martha Wangari Karua, George Joroge, and Musa Omondi. That is the George. He asks, wanted to know the user who logged in on 12 August 2022 at 001 hours. I will take you to R9. It's the registrar's report. I have not filed anything in reference to this, my lords, my ladies. And it shows there was no user. It's the registrar's report. I'm not going to give an interpretation. And I will say the comment under, by the registrar, a review of access laws did not show the user or any suspicious activity. The registrar was represented by an IT technical team. So it did not even request us to lobby the registrar, explain to the registrar. The IT team confirmed for itself. My lords, my ladies, they said there was suspicious activity between various dates. I'll take you to comment 4 by George Joroge. Agent wanted audit logs for user root during the election period. Logs were retrieved from 8th August to 29th August 2022, the day before the election and the day before we did the exercise. There was no suspicious activity. I would like the court to do a simple thing, my lords, my ladies. Compare the logs Mr. Mugo has provided and what is found in the registrar. You will discover there is an apparent discrepancy on the face of those logs. Nothing put on the slideshow is in the registrar's report, because it's not. He may clarify where he got that, but he'll simply refer to the registrar's report. It's not, my lords, my ladies. Now, when you move over the report, you get other clarification by other users, and I want to pick three that are quite pertinent. They say there was no way of ascertaining the date of the server log, and that was the opening comment. At page 22, comment 8 by Victor, agents wanted to know when Form 34C was uploaded. This was established to be 16th August 2022. How could have it been created on 31st August, but you are able to go back in history to 16th August to determine when Form 34C was uploaded? It's ridiculous on the face of it. My lords, my ladies, I'll take you to George again, page 23. The agent requested to see the whole architecture. The whole, not only RTS, not only KIMS, the entire IEBC infrastructure, including everything retained in that server. IEBC database presented the system architecture and explained the transmission flow. How can you say access was not granted when it was granted the entire architecture, not RTS? My lord, I notice my time is running, and my senior wanted to refer to the forover. I will stop here, but if given time, we can take the court through the entire report and answer every query raised satisfactorily, because it was done. Access was granted, that's why comments were made. If access was denied, there would have been no comment. Thank you, my lords, my ladies.
If it may please you, the Honorable the Chief Justice, the Deputy Chief Justice, and other distinguished members of the Supreme Court. My name is Emmanuel Wetangula. I'll be presenting our observations on behalf of IEBC with regard to the scrutiny and the recount that took place on the 31st and yesterday, my lord. First and foremost, I'd like to thank members of the judiciary who took part in this exercise. It's the most tedious and laborious jobs, and not the most, and most people actually opted to run away. And even in the submissions which I'm about to make before the court today, it will be quite notable that none of my colleagues have addressed the pertinent issue. All the results in the boxes matched the results that have been declared by IEBC and the results that were used to declare the president under Article 138.10. Lord, I'll simply give one example. The application for scrutiny was given by the petitioners, and they identified the stations that they wanted. If this was to be a sample of the entire election, the report bears out the fact that out of the 45 polling stations that were counted, there was no variance of results in the 40 stations, 40 of the polling stations. The report clearly shows that there is no variance of the results with that which was contained in Form 34A. But most importantly, my lady and my lords, there were slight errors which will arise, and it always arises in every election. It's typical to human error. And even to point out this fact, my lord, I was reading the report that was prepared by the Honorable Deputy Registrar. It also has a slight error. And that error was corrected today when it was sent an addendum correcting a mistake that had been done. Number two, my lady and my lords, at page 31, you will note that there's a slight typographical error regarding the date of the election. It's indicated as 8th August 2017. A normal error that any human being will make. But if it were the petitioners, I'm sure they will pray that the entire report be disregarded. But my lord, the most important thing is the environment under which elections take place is a very tense situation. And many a times, slight mistakes will occur. For instance, the sealing of documents, the misplacement of one or two things. The only complaint I've had my learned colleagues, Mr. Awele, complain about, Ms. Mboshe, and Mr. Willis Otieno. It's about material not being placed in envelopes. But of utmost importance is having been present with every ballot that was counted. it tallies with what was given to each of the candidates. But most importantly, the allegation the petitioners have made and have been running around with is that election results were being taken from one candidate and being added to another. That fact was not proven. This is their case. And if at all there was any variance in the results, I believe Mr. Willis Otieno will have sung for us a new song today, but he didn't. And that confirms that actually the results are believable. And my lords, these are the results that were transmitted through the results transmission system, first and foremost, having been final. Secondly, these were the results that were physically delivered by the returning officers to the tallying center at Bomas. And my lord, if the registrar confirms that from the boxes that the court has sampled, there's absolutely no variance, then we wonder what the complaint is. The slight variances that, or slight mistakes that were noted, which I will just highlight one of them, that one of the parties picked up on. This is number 38 on the list of the polling stations, Kiheo Primary School. One of my colleagues for the petitioners made reference to it. Despite the absence of the counterfoils, but each of the ballots present matched with the result that was declared for each of the candidates. I wonder how accurate an election can get if this is not it. But mistakes will always happen. And even in the report that is before us, we have noted that actually mistakes actually do happen, and they happen all the time. There was something else that the parties were supposed to deliver, that is IEBC, which was Forms 34A. My lord, a sufficient volume was delivered to the court. I'll just confirm how many there were. There are 32 volumes of Form 32As which have been availed to the court. My lord, there's also the error form, 3 volumes which have been availed to the court for scrutiny, signed by the chair. These are the errors that were noted during the verification and tallying. And lastly, my lady and my lords, before the time runs out, Book 2 of Form 34A, some of it was found in the ballot boxes during the scrutiny, but some of the boxes did not contain, and it's borne out in the report. But the purpose of printing this booklet is actually known to all the players. My lady, my time has run out. I'll just request for 2 minutes to finalize my points, and I'll be done. Thank you. My lady, with regard to Form 34A, Book 2, the purpose why an extra copy was printed, and it's known to the petitioners, but they will not tell this honorable court, was that at any time sufficient copies of the forms will be available to the agents, candidates, and the media. This is to ensure that the results that were being declared at the polling stations being final were transparent and known to everybody. But a contest arose, and a decision was made by the chairman of IEBC that this material was to be sealed and placed in the ballot boxes. As it will happen, in some of the boxes, and the report will bear it out, some of the forms are not there. And even the report will bear it out that some of the presiding officers made mistakes in Book 1. They cancelled it and utilized Book 2, but still the result did not change. What is important and material is from the scrutiny that was undertaken until very early hours of yesterday morning, the result matches what is contained in Form 34A. And my lords, those Form 34As have been availed to the court pursuant to the rules of the Supreme Court, and they are the forms that were used to declare the results of the election upon the completion of the exercise. Similarly, these are the same forms that were transmitted through the results transmission system, and they match each and every other form that was given. Lastly, and very lastly, there was in one station in Kakamega where the Form 32As were not availed, and affidavits to that effect have been given, And the reason is that because of an outbreak of violence, the affidavits will bear it out. With those few remarks, my lady and my lords, Professor Mugai is asking for a donation of the time, but it has run out. Thank you very much.
Lady, without appearing to interrupt the court's proceedings, with that kind permission, my learned friend has made reference to an affidavit that was given. You've never been supplied with that affidavit. We don't even know about it. And I don't think it is proper for evidence of such a nature to be brought to court at this critical point. And I wish the court should ignore it.
I don't think we are aware of it because we closed the filing of proceedings in this matter.
Very kindly request you to allow me to place on record that we reserve our right to object to that document filed by my learned friends. First, because it was filed without leave. Secondly, because no other party has had the opportunity to do the same. Thirdly, because from what we hear now, it may very well contain falsified documents.
Yes. Have we had submissions from the 9 respondents, but now in the yes.
Madam Chief Justice will be making a formal application for the document tendered by Learned Counsel Mr. Mulgo to be expunged from the record. But first things first, we shall respond pursuant to the order issued by the court. We were to orally respond,
yes,
not to use that opportunity for other filings. On our part, 2 of my colleagues will make the oral submissions. Please, that was not within the. Please allow us the 15 minutes. We hadn't started making the submissions.
If it pleases the court, my name is Omwanza Ombati. I'm going to present the first part of or the comments about the scrutiny report. And the second part will be presented by my learned friend, Senator Hilary Sigei. My lords, it's important to first appreciate that the purpose of scrutiny is an exercise that is meant for the court to have an impression of how the exercise of the election was conducted. And that's what you said in 2013, Raila. And secondly, also it's important to note that part of the process of scrutiny is to audit the election and make sure that the numbers are backed up by the paper trail. In the request for scrutiny that was done by the petitioners, my Lord, Chief Justice and members of the Supreme Court, the request was targeted. You'll find that particularly in petition number 5, and also the affidavit of Arnold Oginga, paras 81 to 91. That is where the scrutiny was ordered, and when you retire to consider this matter, my lords, I request that you restrict them to their case. Now, in terms of the orders that was given by this court, you'd find that there are 7 orders. I'll deal with order number 1 to 4. The first one was with respect to an order that IEBC should provide the applicants with copies of the technology system and security policy. This was complied with, except that the applicants also wanted the names, specific names of the system administrators. My Lord, this would not be possible because then you would expose system administrators to danger. The second order is with respect to a supervision of the servers, to have access to the servers of the National Tallying Center, to demonstrate how Form 34C was dealt with. The forensic image of the 34C was granted, and all parties were also given time to interact with this server the whole day. Now, the third and more important, part of that order also was to see whether there was any deletion of any Form 34A at the server. You'll find that at page 21 of the registrar's report. There was no deletion. There is not a single deletion of a Form 34A from the server. And my Lord, Justice Lenola asked a question on how was it that JPEGs were converted from JPEG to a PDF. My Lord, that answer is found at the registrar's report at page 12, and it's important that we read this. It's a short page because a lot of issues have been raised about this. You'll see whereby it says that the Form 34A, you'll find this at page 12 of the registrar's report, that the Form 34A would be scanned by the KIMS kit into a PDF, which was then transmitted into the storage server. At the storage server, the form is processed by an application to check for compliance, to certify that the security features have been complied with, and the PDF has all the features that are supposed to be there. That goes also to page 13. This is important because, my Lord, there was a theory of the middleman that was being propagated by one of the petitioners, and in this scrutiny we could not find any middleman. In fact, there was a direct link from where the results were transmitted. So the transmission was from the KIMS kit. It would go to the National Tallying Center. One form would go to the National Tallying Center. The second form would go to the constituency tallying center, and the third form would go to the portal. And in this path, results path, there was no middleman. That was the smoking gun that was used by the petitioner, and my Lord, unfortunately, there was no smoke, and there was nothing that would find that was found in that. It's important, my Lord, to demonstrate to this court that in the scrutiny, there was first compliance by IEBC about, in terms of the orders of this court, order 1 to 7, as far as was practicable. And number 2 is that in the case theory that was presented to this court completely collapsed. We are all aware, and we saw it, that the petitioner brought a case that was packed in a truckload. However, when that was subjected to scrutiny, it collapsed like a house of cards. So, my Lord, the scrutiny has demonstrated that this election was conducted in substantial compliance with the law. If there are variations, they are minor and they do not materially affect the result, and we submit that this court should validate the win of the first and second respondent in terms of Article 140 of the Constitution. I would conclude and say that from what we've heard, my Lord, it's important probably for those of us who didn't go to the schools that my friend Ayatollah went to, if you read the book of Macbeth, the play of Macbeth, the second play, you'd see that there's a debate. There's a debate about the devil and conscience. I think in one of the last acts, about a servant who's known as Lauserot. And this servant has this big debate on what is it that, he has the devil that is pushing on him and also his conscience. And he concludes that he would rather go, in fact, I quoted this because it's very interesting. He says that my conscience is hanging by my neck, the neck of my heart, and in my conscience is a hard conscience. However, the devil gives me a more friendly counsel, but I choose to run from that friendly counsel. My Lord, with those few remarks, I will request that my learned friend, Senator Hilary Sigei, can continue.
The Honorable Chief Justice, the Honorable Deputy Chief Justice, and the judges of the Supreme Court. My name is Hilary Sigei. My remit in submitting on the basis of the report is limited to the numbers. And my lords, I would dare say, fiction is best told in abstract. My learned colleagues for the petition have taken you through what they called a product of scrutiny. They have intentionally left out what is also equally important besides the process, and that is the numbers. I associate myself largely with the submissions by my learned friend, Mr. Wetangula, particularly with regards to the numbers and the 45 polling stations, which was a subject of inquiry in the orders for scrutiny. Given, my lords, that the election process in Kenya is a process that we are conducting 6 elections in one day, it is natural that errors, especially in counting, tabulation, are bound to occur. But far from that, when the 45 polling stations that this Honorable Court directed that a conduct of scrutiny be done, the recount confirmed that there was correct vote count in 45 polling stations. It also confirmed that all the data that was entered, including, for example, the rejected votes, reflected that which was in the ballot and that which was in the image. It also confirmed that the Form 34As were not altered as it has been submitted before you. I therefore do submit that there are no irregularities in terms of the votes cast against each of the candidates in this particular petition. There was also no transposition the way they had placed that votes from candidate A was taken away and given to candidate B. That product of scrutiny has confirmed that. To be very specific, in Mombasa County, Mvita, polling station 1 of 7, all of them had no variances at all. And in the fullness of time, this Honorable Court, I believe, will spare a moment to look at pages 36 to 49 of the report from the registrar. Majengo, 2 polling stations, no variance, that is page 50 to 57. Mikindani, polling station 1 to 9, no variances were detected at all. In Kericho County, Chebukati'S polling station 1 to 3, no discrepancies were found. In essence, what I'm trying to submit, my lordship, is that the numbers complied in terms of what each candidate had been given as at the time of the tabulation at the polling station and what has been provided and availed before you. I am aware that the 32 volumes of Form 34S are placed already before you. Elections and the will of the people is deposed in the polling station as per the minor Kiai case. I urge your lordships and my lady to indeed look at the 32 volumes of Form 34S placed before you, do a comparison with the 45 which we have submitted, and a report has been placed before you that numbers did not change. If they could not impeach on the 45 polling stations that they pleaded, they cannot impeach on the rest that are available before you. When we look at the other stations they have talked about, Nyandarua, Kiheho, my learned colleague, Mr. Njomo, indeed confirmed that materials were all there in the ballot boxes which were opened. His concern was that they were not placed in tamper-proof envelopes. He's also confirmed that the numbers in those polling stations are there. Those were the submissions by Mr. Njomo on behalf of the petitioners. As regards Oljorok, where he quoted that there were no seals placed, when you look at the report of the registrar in that particular polling station, appearing at page 141 to 171, no polling station had variances in terms of the numbers that were awarded to either the petitioner or my client. In short, my lady, my lordship, I submit that there is no evidence that has been placed before you to impeach the forms 34A, which are already before you and which are in the portal, and which actually is where the vote from the voter, where the voter is expressing their choice of the candidate whom they would want to place in the executive office, was done. No wonder Kenya has moved on. I want to beseech this honorable court to allow that which the people of Kenya made as a choice on the 9th and declared on the 15th to be the choice of the leadership they would want to lead this country for the next 5 years. I am a product of that particular election. The Honorable Madam Chief Justice, allow me 1 minute to close. Thank you. I wanted yesterday, while Malanet Senior, the Honorable Attorney General Emeritus, invited you to ask the Honorable James Orengo and Professor Tom Agenda, I would invite myself to answer that. I am a product of that election that was conducted, and I am aware that if one is clear, the rest will be clear, as we have attempted and have indeed proved in the submissions that are before you. I request and I plead that this Honorable Court upheld the declaration that was made on the 15th of August 2022 of the presidential elections. I thank you for the time, and thank you. I will donate the remaining 13 seconds to the court. Thank you very much.
Thank you very much, Council, and I think we congratulate all of you who have been elected to the new office and wish you well.
For you, I am mandated by my colleagues, and I hope on this one I also speak for my very dear and distinguished friends on this side.
We haven't finished. We haven't finished.
We haven't finished.
Oh, you haven't? Oh, sorry, I wanted.
Yes. Sorry, we wanted to say that we cannot accept these documents, unfortunately, because we had closed the filing and we had indicated that we will take oral submissions on the report by the registrar. So the application to expunge them, I think it's around, they were not even filed, they were not accepted, our system did not accept them. I think there is one clarification or so from the bench. Justice Venara.
Yes, thank you, President. Mr. Murgor, let's go to R10. R10 is users who logged in recently. On this registrar's report, you projected it. So the one which has the Vito, Gudino, Vito, Provisio, Silva, Ogudino. Do you have it?
You would like me to refer to my report?
It's a document. I'm looking at this registrar's report, so if you have it on yours is blank, I'm sure, if you noticed. Yes, that one, yeah. Yes, so go to, not that one. Page, it doesn't have pages, but it's an extra R10. It was the foreigners' logs. Mine doesn't have pages.
I don't have it.
It just reads R10. Anyway.
Yes.
R10 is titled Users Who Logged In Recently. Do you remember that? You projected it here.
We projected it, yes.
Yes, so Vito logged in on July 28th. That's my question. I want to see whether we're on the same wavelength as to the dates. Because you said they logged in during the tally. Does someone have a copy of the report?
We can share a copy.
You can use this. Yeah, please share a copy. Take this.
But this is a...
Share this.
R10. And to save on time, Mr. Ngarisha, you can be looking at R12 yourself.
Yes. Thank you. Okay.
So, Mr. Murgor, you said in, if I... sorry. R10.
Why don't I have this? Okay. Yes.
Yes, so R10, please read for us the dates that these people logged in and the time.
The R10,
yes.
I have the logs start from July 20th to July 28th.
Exactly.
Yes.
So did I hear you saying that they logged in during the tallying period?
That's what I had in my document that I filed.
We are looking at the registrar's report. So how different is your document from this one?
I will check, because what we have has those logs.
Remember, we are working with the registrar's report, not any other document. That's why I was getting confused.
This is probably the reason why we filed our own document, because you have extracted, or the registrar has extracted this part, we have extracted the entire. So we could look at what we have,
yes.
and I will speak to the IT people and clarify that.
But
because our logs start from July
but
to
for the registrar's
August.
report, it's July 20th to July 28th.
Yes.
Okay, so I just want to clarify that. That was before the election, therefore.
That was before the election.
Thank you. That's all I wanted from you. Mr. Ngarisha, let's go to R12. I would have expected you, as you come, to answer Mr. Murgor's concern, which was that R12 is a history of delete and removal actions. Mr. Murgor's concern was activity, and you look at the dates, it is 6th of August at the bottom, and then a lot of activity happened on the 31st of August. I would have expected you to say these deletions and removals relate to this action. Mr. Murgor is saying, following the, and now I think we can disconnect R10 from R12, but I'm concerned about R12. What activities were these? What was being deleted? What was being removed? So that you can get Mr. Murgor's point, which is quite of interest to me. I thank you.
My Lord, far be it from me to correct the court. R12 is a series of command that was firstly executed by the IEBC database manager. I refrain from mentioning her name. She has her own security concerns, but her name appears on the record. Then, that is, I would say, if you look at the page, from 58 to 72 on your left, that is the command running. If you look at R12 on your left, my Lord, there is 58, 59 running. That's the command running, showing there was no deletion. If it was put on the screen in color, you will see what then we did once we realized there was no deletion. Mr. George had a specific command, which he said you can delete or remove from a server. Like in a computer, you can either press the delete key or you can press shift delete. So you can either delete or remove permanently from the server. That command was executed. And my lord, be it far from me to comment on this. The registrar at page 21, James, Khalifa agent wanted to know if a root user has deleted or removed any file from the server. No records of file deletion or removals were discovered. I could interpret the code where you have 72, it shows the library Docker. You have a server which has various compartments called containers. These containers connect to the server by what we call a Docker. It's just an interface for exchanging the communication. It just is up to there. It cannot find any deletion. Then they executed a graphing. Graphing is where you limit the search range. Maybe you wanted to go to the registry and ask how many matters were filed in June. If you ask the registrar how many matters have been filed, you will maybe start from January to August. But if you ask what files were filed in June, that is the graphing. And that's why you see when you read it, it has a graph. Graph, it's not GREP space rem at root after number 72. There is root, application runs. It looks at the log history. Let me, if you will indulge me, let me explain it, my lord. After 72, the root application, which is in that specific container, runs the log history, then it's graphed for remove. Is there any history of removal? There is none. Mr. George then requests, let's check for
That is all we
delete.
wanted to hear. If you still no deletion, that's it. I think we understand what the point is.
And my lord, for R10,
yes,
I could clarify if you'll indulge me.
Go ahead.
If you look at the entire logs, there's what you call an IP address. There's a public IP, and there's an internal IP. The judiciary has its own Wi-Fi that it runs within the court. It has an internal network. Then there's the World Wide Web, where everything that everybody can see. All those IP addresses, compared with all the IP addresses in the entire report by the registrar, they are internal IP addresses. When IEBC was being supported, the same way if you had an issue with your laptop, you'll take to the judiciary technician. They were being supported because they purchased a software and they needed routine maintenance. And my lord, before you say this is my own assertion, I will take you back to the registrar's report, whereby they searched between August, the entire month of May to August, for any deletion, removal, there was none. Then we searched for the entire August, whether those users accessed. The answer was none. I will adopt this report in entirety. See, for maybe a few comments I would have, but that's bickering over the minute, my lord.
Thank you very much.
Much obliged.
Thank you, CJ.
My lord, just a quick one. The page you refer to as R10 appears to look very similar to this page 16 that I had provided. All I'm saying is that relates to dates in July, and what we received from IEBC contains logs up to the 31st of August. But the two last entries in August 31st and 24th are attributed to Root, who we believe is one of the same gentlemen, but the one I referred to today was August 16th. So it's just a question of how long the log was. Check again on your side. And then finally on the issue of the deletion, our position is that there was obvious deletion, and what we found there was empty, recently modified file, and certainly not a server that could hold the entire election in the Republic of Kenya.
Thank you very much.
I want the record to show, with your very kind permission, and the concurrence of all my distinguished friends, learned friends, particularly those to my right, who have accorded me the honor of making this speech on their behalf. We thank you most sincerely for all the time and effort that you have put, and your patience, and putting up with some of our not very honorable conduct. We apologize for that, and we wish you good deliberations. Thank you.
Thank you, Senior Counsel Professor Githu, Attorney General Emeritus. From this end, and before our team leader speaks, we want to thank you for your assistance to us in the last 3 days. We want to say that if there was bad manners, we didn't see it. It's happened, and there really wasn't bad manners. We thank you for working within the very strict timelines that we gave you. Now, if you felt pressed for time, blame yourselves, because you gave us 14 days to do what ought to be done in a year, if you ask us. And while you take a break today, we continue working. We thank you, truly thank you on behalf of the team and before the team leader speaks. What you didn't know, but you may have realized, is that every day there was a marshal or a prefect from this end to ensure that you kept to your lanes. If you didn't notice, today I was the marshal. The day you laughed most, Dr. Wanjala was the marshal. That's how we work here. We work as a team. We divide roles here so that we don't all speak at the same time. And here, unlike things we have heard you say today, we consider ourselves equal. None of us has a veto power, but of course we have a team leader. We thank you very much. Pray for us as we undertake the next phase. It's actually not the more difficult one. You have helped us with the more difficult part, but it is intense, for which reason, therefore, we ask you that you pray to whatever God you pray to, that God will assist us to continue in the spirit we've been in for the last 1 year, and that we shall have a very high sense of discernment, and that we shall return to Kenya a judgment not less than what Kenya expects. Thank you very much, and now I ask that the team leader speaks to us.
Thank you very much, the Honorable Vice President of the Court, and for being a very, very effective marshal for today. Allow me to thank my brother and sister judges. We actually call it shared leadership in the judiciary. We take up all this responsibility together, and I'm most grateful for that. Thank you, Senior Counsel Professor Githu, for those very kind words. All we saw, like the DCJ is saying, is very, very robust arguments and participation. We did not reckon any bad behavior. Like you see, we did not cite anybody for contempt. So we are very, very most grateful for your cooperation. Allow me also to thank the other people who worked with us round the clock. A team led by the Registrar of the Court, Honorable Letitia Washira, and the Deputy Registrars, our law clerks who have been supporting us, all the industry staff, the executive officers, and the court assistants. We also want to recognize the role played by our security, our police unit and all the police officers and security people who have provided us with security round the clock to make sure that these proceedings move on smoothly. I may not be able to mention everybody, but also to say that anybody who did something to make these proceedings move smoothly, we are grateful to them. We also want to thank the international and local observers who came to observe these proceedings. We are grateful for your encouragement, and we continue to ask, like the Vice President has said, that you continue to pray for us so that we can render judgment that promotes our constitution, that is anchored in the law, that nurtures our democracy, that brings harmony to our country, and everything good that is stated in our constitution. So with those remarks, I will wish you a very nice evening, and as we retire ourselves to continue working. Thank you very much. I'm told that we will deliver our judgment on Monday the 5th. We shall give you notice closer to that day. I don't know, we have only tomorrow and Sunday. But we'll give you notice indicating the exact time when that will be done. It will definitely be on Monday. But I'm reminded that Monday lands up to midnight. So you'll be given the time indication in the notice. Thank you very much. Have a very nice weekend and nice evening.
No, we have spoken through our...
Thank you very much. I will invite the Honorable Justice Ouko to begin with these questions.
Thank you, Judge President. I have a couple of questions. I'll start with Mr. Mahat, who, without leave, proceeded to convert this courtroom into a classroom. Mr. Mahat, there was an allegation that 33,000 vote differential were noted between the votes cast for the president and those for governor, senator, women rep. You tried this morning to explain that some of those instances arose from stray ballots. Would you tell us how many constitute stray ballots? And can you also share with us how those stray ballots are distributed in terms of counties? Related to that, did you have, in your analysis, did you have any instances where voters walked into the polling station, voted for the president, and no other candidate or no other category of candidates? What in this court we call the Mwilu question, in reference to my lady, the vice president, I think arising from the 2017 question that I think my lady and my lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IEBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission or he was gazetted as national returning officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters who were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Raro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it, and what is the approach you should take in this case regarding the test to apply? Number two, again to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did he not wait until that day? Violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyo and Mr. Kihara and the rest are coming from. We are now in a sport where public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination? What do we do with the matters you placed before us? And while you're at it, you also mentioned Section 83. Perhaps you could also say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus but as a respondent, could you say something about Regulation 87.3 and the question I posed to Mr. Noroji? It would be helpful for us if you could hear you on that question. I believe those are my, Mr. Mahat, I may have missed this, but I still want to clear my, this is a question I posed to Mr. Murgor as well. So the format initially is JPEG. At what point exactly does it convert to PDF? forget the CSV story. I guess Mr. Mulgo dropped that. But I just want to understand for myself. At what point you've taken the image, you've asked all the questions, very good questions you've asked, the system has asked you the question. At what point does it convert to PDF? I thank you all very much. Thank you, Judge President.
Thank you, Judge President. My questions will go to Professor Muigai, as we've been asked by a number of parties that they've asked us to settle the law around Article 138.3 and 10. In your submissions, you suggested that the term commission can be used in multiple senses. How do we know which sense will be applied when? As a former Attorney General, perhaps you can point out to us whether it is in regulations, it is in the law, but how do we know which sense is applied when? My second question goes to the history of independent commissions, and Professor Muigai, you sat on the CKRC together with my colleague, Justice Lenaula, and you do know that the drafters of the Constitution introduced independent commissions and independent offices to deal with issues of authoritarianism, accountability, transparency, and to do away with the issue of one person having power. But from the narrative that we are hearing here in the court, there appears to be an all-powerful chair who, so what is a check for this all-powerful chair if the commissioners have nothing to do with his role? What would happen if the chair was to announce the wrong results completely? Or if he was mentally incapacitated or sick, or worst case scenario, dead? Who then would announce the results? What is the role of the other commissioners? I think this is bothering me, especially because it seems to me that your client and the IEBC suggest that the chairperson works with the CEO, and I feel a bit concerned. The CEO is not vetted by Parliament. He is appointed, but he seems to wield immense powers over and above the other commissioners. I cannot imagine that that could have been the intention of the drafters of the Constitution. So what role do these commissioners actually do? Because it hasn't come clearly. Or, for example, if one commissioner says he's in charge of ICT, what does that mean? Does it mean he's in charge of ICT until the presidential election, then he's not? What does it mean? What is the role of these commissioners? And I'm asking this question more towards trying to understand the leadership and the management in the commission as opposed to the management of the presidential election. Because I think they're two separate issues, and I'm trying to figure out whether this is a Chebukati problem, is it a leadership problem, is it a commissioner's problem? What's this problem we're seeing? I'm trying to understand that, and I'd like to hear that from you. Thank you. One more question, sorry. When the results come for other elections, so you have returning officers for senator, for governor, for MCA, and they're all announced or declared locally at the polling station, constituency, county. How is that information transmitted to the public? And when that information is transmitted to the public through a gazette notice, are the commissioners involved? Or is it the CEO only? Or is it the chairperson only? Who is involved in the declaration or the transmission of declaration publicly of those results? Thank you.
Thank you, Chief Justice. My first question, I think, could be addressed by Mr. Karori. In the morning, you did really argue quite strongly that when it comes to verification, tallying, and declaration of the result, the presidential election result, that really if you look at the law in your interpretation of the Article 138 and the jurisprudence that you say emanates from this court, you seem to be arguing that that is strictly within the purview of the chair's mandate, and that really these other commissioners, let's say the remaining, the 6 commissioners, really ought not to be around that, because that's a role preserved for the chair. But then you said, according to the statute that establishes this commission, the enabling statute, the roles and functions of the commission, commission, are stated. One of them is oversight. What is oversight? If, in fact, the commissioners, I would have thought that one of the most important oversight roles in the commissioner's life would be when they are overseeing the verification and tallying of the presidential election result at the center before the same is then declared on behalf and for, and but for the people of Kenya by the chair. So what is oversight? I ask this because we were informed yesterday, and I think you were here, that instead of perhaps playing this role, some of them were allocated welfare scenarios, protocol, and media. But what is oversight? What would they be oversighting over? That's the question. In other words, at what point in this corporate entity scenario does the chair then disengage from the other commissioners? Be they 2 or be they 5 or 6? When do you say this is chair qua chair and this is chair as part of the commission? Because we need to understand that. We've been asked to provide clarity. Then let's go to Mahat. Mahat, there is this story about this Venezuelan. And one of the issues is whether the technology system employed or deployed was penetrated. And you did tell us, again, quite robustly, that there was no such penetration or infiltration or intrusion, whichever. But you did also concede that this Venezuelan, whatever his name is, had access to the server. But your answer was that the contract between the IEBC and Smartmatic was to supply and maintenance. So if I understood you correctly, this Venezuelan was accessing the server as part of the maintenance. So what is this maintenance? What does it entail? What was he doing there? Say he was released and locked out just before the election. So what was he maintaining in that system? Maybe you just want to tell us what maintenance entails as part of that contract agreement. Then back to the question of percentages, again, in terms of the turnout. I think I asked this question, I asked Mr. Orengo, but now that you may not have another, you may also want to address it. In the arguments that have been presented before us, Mr. Chebukati, the chair, first mentioned a 65.4% turnout. And then he did indicate that that was bound to change as results kept streaming in, especially if you took into consideration the number of those who had voted manually and the numbers that had yet to come in from the elders. Now, it is the petitioner's argument that if there was to be any change at all, then that percentage would have to increase rather than decrease. So I don't know. And how relevant, again, is this turnout to the determination of whether a candidate gathered 50% plus one vote? And then, you see, we have been asked by Mr. Ngatia, who do you believe among these two protagonists? Who do you believe? This question has been put to us, and believe you me, we will have to deal with it. Who do we believe? Now, the question of the National Security Advisory Council. This, I think, Mr. Oraro, this could be of interest to you. On the one hand, you are telling us that this personnel visited the premises at the Bomas to express their concern, because, of course, being an advisory council, they must have arrived at a conclusion that unless the results were released, then there was bound to be chaos. But on the other hand, the chair, in his affidavit, tells the court that the only reason the AG, or I mean not the AG, but the individuals, distinguished people for whom we have a lot of respect, paid that visit, was to tell the chair to somehow re-engineer the results in favor of one of the candidates. Now, this is not a question to you, but a question to Mr. Chebukati'S counsel. Professor, you may want to, or even Mr. Karori, are we to assume that by the time Mr. Kinyo placed this call, if the intention was to influence the declaration of the results, to change it, to re-engineer it, are we to assume that by the time that call was placed, and by the time this gentleman paid this visit, they already knew the results? Because there's no way they would have been on that mission if they had not known the results. So are we to assume that in fact, if this be their mission, are we to assume that they already knew the results? Okay. Then finally, Mr. Koome, you know, you cited King Solomon. And this court treats Holy Scriptures very seriously. You came up with, you say there is victory. Because in King Solomon's story, the protagonists were distinguished mothers. But here, you called them two gentlemen. But I also remember that one of the mothers who turned out, or the mother claimants, who according to Solomonic wisdom could not have been the mother, is the one who was saying, cut the baby. But the other one, I remember, said, no, let her take the baby. Because what she was interested in is to preserve the baby. Would you be willing to advise? I rest my case,
Okay. Thank you, Honorable CJ and President of the Court. I just have one inquiry, one question for the respondents, and it may go to, actually it may be answered by either the counsel, Senior Counsel Gidu Migai and his team for the first and second respondents, or it could also be taken up at the same time by counsel for the ninth respondent. That is the team of the team of Senior Counsel Fred Ngatia. It's my understanding that one of the submissions and cases in response by the first and second respondents, on the one hand, and the ninth respondent, that is the President-elect, are placing the blame on the events of the 9th at the Tallying Center, Bomas of Kenya. That the two groups of parties are placing the blame on the first and second petitioners' agents and sympathizers and supporters during the tallying and verification. Of course, we have images. Many of us were not there. At least the bench was not there. But we have images which we saw on TV. We cannot say anything about what exactly happened. But we just know there was commotion, and people are throwing chairs and even perhaps attempts to harm each other. But we cannot say anything about it ourselves as a bench. Neither were those matters before us in these proceedings. No evidence or allegations, the affidavits. We have seen the affidavits, seen the submissions, but